Hey, good morning, everyone, and welcome to the Historic Courthouse. To our visiting students from the Catholic University program, apologies if I mispronounce this, but G.W.J. I got head nods. Sounds like it worked. Today is Tuesday, June 3rd, and we have three cases on the docket. I am Associate Judge J.P. Howard. I am joined to my right and your left by Associate Judge V.J. Shanker and by our colleague to my left from the Superior Court, Judge Carmen McLean, who is with us for this. We have, as I mentioned, three cases on the docket: Miller v. United States, G.W.J. v. United States, and Perkins v. United States. We will call the first case 23 CF 0828, Miller v. US. Is counsel ready to proceed?
Good morning, Your Honors, and may it please the court. Victoria Hall Palerme on behalf of appellant Andre Miller. I'd like to reserve 3 minutes for rebuttal. Mr. Miller's convictions must be reversed for several independent reasons. Today, I'd like to address 3 of those reasons. The magazine should have been suppressed, the evidence of Mr. Miller's knowledge of the magazine's capacity was insufficient, and the jury instructions were plainly erroneous. Because this court heard argument in December on the same constitutional challenge to this very statute, and mindful of my limited time, I don't plan to address that issue, though I am happy to answer the court's questions. First, both convictions must be reversed because the magazine should have been suppressed. The testimony at the suppression hearing, even when combined with Officer Strong's later testimony at trial, failed to establish that Officer Strong had probable cause to believe that the magazine was contraband or probable cause to believe that it was evidence of other criminal activity. The trial court erroneously concluded that Officer Strong had probable cause to enter the car because he could believe the magazine was contraband without making any findings as to whether Officer Strong could tell its unlawful capacity. The court simply concluded that it was very clear that it was a gun magazine. To the extent that the court's ruling rested on the conclusion that any magazine, regardless of its capacity, is per se contraband, that is legal error. The government doesn't really dispute this, as on my reading of their briefs, because a magazine holding less than 10 rounds, or I guess 10 rounds or less, is perfectly legal. Officer Strong would have had to know and have some other information or reason to give him probable.
What about this alternative point that put the ammunition within his reach in violation of another statute?
So the transportation statute, I think that sort of the government's reading of that statute, we don't necessarily agree. So first, my first answer is that the government appears to argue that the magazine's position in the car is a reason to believe that the magazine was unlawfully possessed. I don't really see how, as a logical matter, that follows. I mean, a magazine that is lawful or unlawful could be being transported unlawfully. Second, I don't actually think that that's the correct reading of the transportation statute. The statute says that if a firearm is being transported, then neither the firearm nor any accompanying ammunition can be within reach. But at the time that Officer Strong looked into the window, they hadn't found a firearm and all he could see was a magazine. So I don't actually think that under the plain terms of the statute, that would have been a violation of the transporting firearms statute.
So I'm a little confused about the facts, and this relates to your main argument too. Putting aside what he could actually see when he looked through the window, and I realize that the photograph that we have doesn't necessarily reflect that, or at least that's your position. Is the gold that you can see, are those bullets, or are those just slots for bullets in the magazine?
So the holes that you can see, before I answer this question, I want to say, we are looking at a photograph that is blown up and much more high resolution than necessarily what someone looking in the car could see. But the holes you can see are holes for bullets. I, just looking at the holes, not knowing anything, would not necessarily know whether there were bullets inside those holes or not. Officer Strong testified that he could see the shine of the bullets, and this is the kind of gun that the officers carry. So he knew that there were bullets inside the holes. But the question is whether the magazine is capable of holding.
Well, I mean, I was only asking this with respect to the 224504, the transportation statute, because I mean, I see your point about the statute not necessarily covering an ammunition device, but it does cover ammunition. And so if there actually, if Officer Strong had probable cause to think that there were bullets in the magazine, regardless of its capacity, then it would arguably fit under 4504's ammunition aspect?
So actually, our position is not that it doesn't cover a device, though maybe that is a better position, but our position is actually that the statute says, and I'm reading it now, if the transportation of the firearm is by vehicle, then neither the firearm nor any ammunition. So our position is actually just that without a gun, the ammunition on its own is not in violation of the statute either. And sort of that makes sense, because if the concern is safety, if you're traveling with a gun and ammunition, you want to keep the ammunition locked up. But if all you have is ammunition, which cannot on its own sort of cause risk or harm, it's not clear that that falls within.
Well, we don't really require that 2020 kind of hindsight, do we? Like if the magazine is there, then why is it not reasonable for the officer to think a gun could be there and they can proceed further?
I mean, I don't think that that is what the sort of cases that we've cited about probable cause and plain view exception say, that before the time of entry, the officer needs to have the facts known to him that would give him probable cause to believe that there is contraband or criminal activity afoot. And just seeing a magazine, when a magazine that's capable of holding 10 or fewer bullets is not a crime, is not probable cause of a crime.
In your briefing, and I know this relates to multiple other points, and so apologies for potentially pulling you around in a couple directions. You acknowledge that your client acknowledges that the vast majority of standard magazines hold more than 10 rounds. I think vast majority was not the specific language used, but it was more than half, up to 70% maybe. Why is it unreasonable for an officer seeing that if, as you just said here at the podium, they know the kind of clip, it's with the kind of magazine, it's the same, it goes with the same kind of gun they use. They wouldn't be able to tell if this was crimped or modified to make it contain less unless they went to it and pulled it up and were able to look at it. And I know it's kind of compounds.
No, I understand the court's question. I think, well, first, I want to stress that the problem here, right, is that there's just nothing in the record about that at all. It might be the case that had the government called Officer Strong to testify at the suppression hearing, and he had testified to either statistical data or to his experience of, every single magazine I recover in this area has more than 10 rounds or something like that, this would be a much harder question. I think we would still have some arguments about whether statistical data has a sufficient sort of nexus to the conduct here, but it would be a different case if there were any evidence in the record about the frequency or sort of ubiquity of the magazines in the District of Columbia. But here, there's no evidence at all. All we have is Officer Way testifying from Officer Strong's body-worn camera, which he concedes doesn't capture the magazine, and a photograph that's taken from a different angle with the car door open, with the overhead lights on, and Officer Strong's testimony there's a mag in there. And I think that all combined still doesn't give rise to probable cause that he believed that he knew that the magazine was contraband.
So, go ahead.
If an officer saw through a closed window, white powder in a Ziploc bag, could be baby powder, could be narcotics. Where do you stand on plain view at that point?
I think that the cases are fairly clear that would be plain view, and I think that's because there's sort of an inference that there's not really a reasonable, you wouldn't be traveling with your to-go baby powder in a Ziploc bag, right? Like here, the problem is that there's a lawful way to have a gun magazine, and there is an unlawful way to have a gun magazine. And the police, before they conduct a warrantless search of your car, need to have facts that would show or suggest that it is the unlawful version of having a gun magazine. So in this way, I think it's less analogous to the white powder and more analogous to when they look in the car and see some unspecified amount of marijuana, right? In Harris, this court sort of took as given that they would need to have probable cause to believe that it was more than the prohibited 2 ounces to go into the car. The fact that you need to know is the fact that makes it unlawful. And so here, we just don't think that the record contains those facts. And so we think that the magazine should have been.
So along those lines, extrapolating one step further, and I completely agree with your point, your description, which I find accurate, of the testimony that was given and what we see kind of in the record here. If Officer Way were to have testified even from that body cam footage, well, he said there's a mag, and if we see a mag, then goes into that statistical evidence or anything else. Do you think that would have been sufficient?
If Officer Way had just testified that there's a mag, I don't think so. Without
not that there's a mag, but the descriptions that we were talking about the vast majority of magazines having beyond the capacity, et cetera. I'm sure there'd be a challenge to, does he actually know that? but do you think that would provide a stronger base, or is that?
I think that would be a much closer case. I think if the officers could provide particularized sort of specific evidence about their experience, about, the rate of recovery of certain kinds of magazines in the area. I don't want to take the position that we wouldn't be here disputing that either, but I think it would be a much closer case than one where the record is devoid of any of that evidence.
Thank you.
So then moving on to the sort of sufficiency challenge, under this court's decision in Bruce, the government is required to show and give the jury sort of evidence from which they could conclude beyond a reasonable doubt that Mr. Miller knew that the magazine could hold more than 10 rounds of ammunition. And I just don't think that the evidence in the record that was presented to the jury can get them to beyond a reasonable doubt.
So I get your point that, or I get your position that the government is conflating constructive possession with knowledge of the features of the magazine. But I would ask you, my concern is that, well, I'm not sure they're doing that. And so the point is that you have to establish, obviously we wouldn't be here if they couldn't have established constructive possession or actual possession. And so that can't necessarily lead to an assumption that there was knowledge of the features of the magazine. But constructive possession does require, as one of its elements, knowledge of the presence or location of the item in question. So if we assume that, and it doesn't seem like your client is challenging the sufficiency of the evidence on that point, then isn't that a factor suggesting that that your client had seen the magazine? And then my second part of my question is, then isn't this distinguishable from Bruce, where we pointed out specifically that the magazine was inside the firearm and was not visible, as far as the evidence showed, was not visible to the defendant?
Sure. So I want to take those sort of in the order that the court asked them. So the first question, we agree that the evidence that can show constructive possession is sort of relevant to and can perhaps in some cases show knowledge of the sort of prohibited aspects and characteristics of the item. The argument here, though, is that given the sort of evidence of constructive possession, including how the government argued it in closing, where they said to the jury, we don't know whether Mr. Miller ever had it in his hands. We don't know whether he ever had it on his person. All we know is that it was in his car where he had the intent and ability to control it. So they sort of expressly disclaimed any kind of argument that rested on him holding it, looking at it, knowing anything about it. I just don't think the evidence here can get you there. There might be some constructive possession cases. For example, the magazine is sitting on someone's bedside table where they come and go, where the inference would be stronger that of course you would look at it and know the prohibited characteristics. But here, where the magazine is sort of sitting in an obscure position out of view, it's a piece of black plastic in a dark car on a dark night, I don't think that the sort of evidence of constructive possession could necessarily get you there. As to your question about Bruce, I do, agree that that is a distinguishing feature of Bruce. There, the magazine was inside the gun, but it's worth sort of looking at all the other facts at issue in Bruce that would have pointed to the defendant there having knowledge of the magazine. So first, right, the court held that he knew that the magazine was loaded, that he knew that there was ammunition inside the gun. And they drew that from the fact that his DNA was on the firearm. It was sort of the magazine or the gun was placed in what the court called an awkward position, barrel down on a shelf in the kitchen where Mr. Bruce had just walked away from it, giving rise to the inference that he had stashed the firearm. And the court concluded from all of the evidence that Mr. Bruce was engaged in drug dealing that he would have had sort of reason to know that this was his gun, that he carried this gun, that he wanted the gun to be loaded. All of those facts could show that he also knew what was inside the magazine, and yet this court found that that was insufficient as a matter of law without more. The opinion in sort of my reading of it doesn't really rest on the fact that the magazine is inside the gun. It rests on the fact that a magazine's capacity is not a feature that is readily apparent. And that's sort of right in line with the cases from Massachusetts that we've cited, Cassidy and Resendi and Thompson, where the question is whether the magazine is obviously large, right? There might be some magazines where just laying eyes on it for even a fleeting moment gives you enough to know, wow, that's a really big magazine, right? Like the testimony about the magazine under the car, big magazine. But there are other magazines that look sort of identically sized to a lawful magazine. And in those cases, the government is required to show some more knowledge, either through, for example, DNA or fingerprints on the magazine, through if any of the witnesses had testified that they saw Mr. Miller sort of looking in the direction of the magazine.
But looking and fingerprints only get you part of the way to the point I think you're trying to make, because that just shows that the defendant had eyes on and I guess hands on the item. But you seem to be arguing that at some level, the government would need to prove that the defendant actually counted, right? And that seems to go a little too far.
So I agree. I don't think that our argument is that they need to prove that he actually counted, but I think they need to give evidence that would suggest that sort of it would just be unreasonable to suggest that you wouldn't have known, right? So if there were, for example, DNA evidence on the magazine suggesting that it had been in his hand for some meaningful period of time, the inference that he looked and saw the holes grows a lot stronger. Here, there's sort of nothing that suggests that he knew anything
I
about the
mean,
magazine.
this just comes down to who made the better argument, but on the one hand, you can have constructive possession based on something that's in the back seat of a car under a bunch of clothes. It would still probably be constructive possession, but that would be further on the other end of the spectrum. Here, the government's point is it was in the front passenger's, area of the car. I'm sorry, the front driver's area of the car right next to where he was sitting, and so he must have seen it. That's not really a question. I guess my point is just that there's a spectrum, and where this falls on the spectrum, I guess is for us to decide, but.
Yeah, no, I think that's fairly accurate. There are some cases, if it were hidden under blankets or in a compartment or something, where it would be more straightforward to find that he didn't know anything. And then there are some cases like Cassidy, these Massachusetts cases, where it's an extremely large magazine that protrudes past the grip, and Mr. Cassidy himself testified that he knew a lot about guns. Like, that's a very easy case. But this case, I mean, I would say I would sort of dispute the characterization of the magazine and how obvious the capacity of the magazine is, right? Like, we are looking at a photograph that has, again, taken with the door open, with overhead lights on, zoomed in. But at the end of the day, this is a piece of black plastic about yay big that on the picture is sort of sitting behind the driver's hip, sort of behind where the lever to move the car back and forward is. It's not necessarily
Where it could have fallen out of his pockets, just like my keys often do.
It could have, but it also could have just been sitting. I mean, we simply don't know. And the government told the jury, we don't know if it's ever been in his pocket. We don't know if it's ever been in his hand. It could be that as he was leaving the house, his friend said, hey, I put a magazine in the car, don't lose it. We just don't know. And, as this court has said in Rivas, for the jury to have sort of confidence beyond a reasonable doubt is not a toothless standard. They can't sort of delve into conjecture or speculation. They need to have concrete evidence.
But at the same time, we also tend to press that the prosecution doesn't need to disprove every possible theory that's thrown out without evidence there. And in this case, where in the record is any sort of other kind of evidence that, someone was in the car before, someone used the car, like anything else that would point away from him?
There's nothing in the evidence that would point away from it, but there's also nothing in the evidence that would point to it. And because the government bears the burden to prove it beyond a reasonable doubt, I just don't think that showing the mere existence of a magazine in the car on a dark night that's not obviously large can get them there by the sheer sort of existence of the magazine.
Well, and let me ask you also, and I do think, it is the government's burden of proof that they have to prove everything beyond a reasonable doubt. But as you're arguing, that it really begged the question to me, is there a point that I don't have to always assume that someone with a gun doesn't know its characteristics or its components? Like, I'm not saying that that's a finding for us to make or anything like that, but it does seem kind of quizzical to me that if someone had a gun, they just never bother to check it.
So I think this question sort of feels to me analogous to the question that the court considered in Bruce, right, where the government argued that there should be strict liability for knowledge of the prohibited or sort of characteristics of the magazine, because when you have something, so the argument goes, when you have something dangerous like a gun or a magazine, you were sort of charged with knowing the things about it that make it unlawful. And this court in Bruce said, no, that's actually not consistent with the presumption of mens rea. And so we are not.
We absolutely said that was wrong, but imagine the hypothetical, which again, taking you beyond the record of this case, where it's established that, individual A, not necessarily Mr. Miller, had possession of this weapon for any meaningful amount of time, or the weapon that the magazine went to. You would agree that much like in the other case, where the individual testified that, oh yeah, I know guns, that would be some sort of evidence that would tend to lean the other way?
Sure, if there had been testimony that he knew a lot about guns, that he had this magazine in his car always, that he had honed it for a significant period of time, I'm not saying that would necessarily get them there, but that would be some evidence that would give the jury something to work with, and sort of none of that evidence is in the record here. And then sort of even if the court finds, which again, we don't think they should, but even if the court finds that the evidence was maybe sufficient for a jury to conclude it, I think at a bare minimum, the evidence was not uncontroverted and overwhelming such that the error in the jury instructions, which the court concedes was plain, affected the outcome. There's a reasonable probability that it affected the jury's verdict. And so at a bare minimum, this court should reverse and remand for a new trial. But we think that, you know, if the court finds that the evidence was insufficient, then it should just reverse. Unless the court has.
Sorry, I just have a quick question. I know that the Second Amendment issues were discussed in Benson, but if we were to have to reach that question, I'm curious about your position on Mr. Miller's status as a felon not being relevant to his ability to raise this argument.
Yeah, so we don't think that his felony conviction really has any weight in the analysis because his felony conviction is sort of not a fact that sort of has any application in how the statute was applied to him, right? Whether or not he had a felony conviction here, the outcome would have been the same because he had a magazine that was greater than 11 rounds. And so it's not sort of part of the as applied challenge. And if the statute is facially invalid, it's invalid in all of its applications. That's what this court said in Conley and Valdez. So we just don't think that, at least on the merits of the claim, that it has any relevance. And then on the sort of quasi-standing argument, it's doubtless from sort of Plummer and other cases that he has standing to challenge the statute of which he was convicted.
Yeah, I mean, it's not exactly a constitutional standing question. It's more a sort of prudential redressability question. I mean, I agree he has standing as convicted, as the convicted person, but if he would still be barred from possessing this item regardless of the relief that we ordered with respect to this particular conviction. So at some level, it does dovetail into a sort of prudential redressability standing piece. And that's the part that I'm trying to get a little more clarity on.
Sure. So there are some cases that suggest that there's a sort of prudential standing doctrine. This court doesn't always apply it, right? There are some cases where it does, some cases where it doesn't. And we would submit that it sort of doesn't really make sense to apply it here because the whole point of prudential standing is to avoid getting into thorny constitutional questions that aren't fully presented. But here, to accept the government's argument that people who have felony convictions, regardless of how old, regardless of what the underlying conduct was, regardless of how many years have passed, that forever bars them from any exercise of any Second Amendment rights, that is sort of not a very obvious question. That's not something that is sort of open and shut that would avoid answering hard constitutional questions. That itself is a hard constitutional question that we think Rahimi has left very much open, that hasn't really been fully briefed, that is actually not really fully fleshed out here. And so it wouldn't really be avoiding hard constitutional questions to rule on that basis. It would be walking into a different hard constitutional question. Whereas the merits of his challenge to the PLCFD statute is sort of not, it's within the heartland application of the statute, if that makes sense. It's not like he has a 100-round magazine and we have to decide whether that is within historical tradition or not. This is a 17-round magazine. That question is in many ways sort of more straightforward to answer than the question of his felony conviction.
Any further questions? All right, thank you. We didn't ask you about any time you reserved, but we'll reserve a couple minutes for you.
Thank you.
As you come up, counsel, can you let us know how y'all will be dividing the time?
Yes, Your Honor. Good morning.
We're going to hold you strictly to it as our tradition is.
Thank you. Good morning, Your Honors. May it please the court, Catherine Kelly on behalf of the United States. I would plan, if allowed, to argue for 10 minutes on issues other than the Second Amendment issue, and then reserve 5 minutes whenever the court would like to speak about it to our intervener counsel from the DC Office of the Attorney General. He would address the Second Amendment issues for 5 minutes. Just from the outset, the only thing I will say about the Second Amendment issue is that the Benson case may not be dispositive here because this defendant clearly was a felon, and I'd be happy to leave it to intervener counsel to discuss the nuts and bolts of that. In regard to this argument for suppression, there is no grounds for which this gun would, or the magazine would be appropriately suppressed here. Number one, in this case, regardless of anything else, this magazine sitting out in the passenger area of the car was evidence of another crime, which was gun possession. This case started with a call for traffic crash, which was then elevated to a call involving a man with a gun. So Officer Way, before he even started driving there, had reason to believe that a man with a gun was something he was going to confront. So we have that. We get there, Officer Way sees Mr. Miller getting out of the driver's seat of a car that is registered to him and walking across the street with a backpack in his hands, putting it down and then fleeing. And in the interim, as Officer Way is getting out of his own vehicle, a woman who's standing in the middle of the street points at Mr. Miller and says, "He's got a gun, he's got a gun." She's yelling this at the officer. So this is not a situation where this magazine is discovered in a vacuum in the car. There was reason to, using the collective knowledge of the police, to seize that and know that it's potentially evidence of the defendant's gun possession in this case. So regardless of size or anything else, that is number one reason not to suppress here. In addition, the point being regarding that the magazine was sitting in the passenger compartment is like, yes, there wasn't a gun found in the car at that time. However, there's certainly reason to believe that the defendant did have a gun. In addition to that, you have the situation where if you're, in order to have ammunition, and granted, there is no challenge to the sufficiency or to the suppression of the ammunition here. If you have ammunition, you have to be a registered certificate holder for a gun. And in that position, you're expected to know what the rules are about handling of guns, ammunitions, and so forth. So an officer goes to a car and looks in and can see that there's a magazine sitting in plain view right next to the driver's seat. There's reason to think that that's not going to be a registered handgun that's related to. But even in addition to that, given the testimony by Officer Strong, and mind you, his video of his body-worn camera footage was shown in the suppression hearing. Officer Strong testified at trial that
Can
what
I
he-
ask you on the body-worn camera video, what did it show aside from the statement, "There's a mag"?
You-
That
you
would
can
lead
s-
us in this direction?
you can see the manner in which Officer Strong is looking at the car with the flashlight. So he isn't just giving it a cursory look. He's standing quite close to the car. He's pointing the flashlight down in the area of the driver's seat and would have illuminated where the magazine was found. And as he testified at trial, he could see the shine of the bullets. That's
Well,
how he
so
knew it was
can I
loaded.
stop you there on a side question, which is why is his trial testimony relevant to us with respect to suppression? He didn't testify at suppression. And we've gone over this a little bit in other cases, including Mayo in a footnote. I think the most we've said is that trial testimony is relevant to us in affirming a suppression ruling, which you're asking us to do,
Correct.
obviously, but only to the extent it doesn't conflict with suppression testimony. And I guess
Correct.
your argument here is it doesn't conflict with suppression testimony because he didn't testify at the suppression hearing. But basically what you're asking us to do is take trial testimony standing alone and use it with respect to a suppression ruling. And I'm not sure we've ever said we can do that.
Well, what we do have here is Officer Strong's body-worn camera footage was shown at the suppression hearing. You can hear him saying there's a mag in there, and I'm paraphrasing. In addition to that, there was a photo of the magazine as it was found in the car.
I don't think the photo, speaking just for myself, I don't think the photo moves me anyway, because it's a completely different view. The light is on, the door is open. That can't be how he saw it.
Well, in the point with the overhead light being on, Your Honor, the flashlight is very bright. That's another thing I would say that you can see from the body-worn camera footage of Officer Strong.
I mean, I saw glare
That's
coming
what's
off the
fresh.
window when he shone the flash, shown the flashlight through the window. I
Mhm.
mean, we could argue all day about what can be seen from that body worn camera footage, and I don't think we need to do that, but I just don't think my view of the body worn camera footage is that it doesn't really tell us what he actually saw. And the photo definitely doesn't tell us what he actually saw because it's a completely different circumstance there.
I would say the photo that was shown, and it was a mistake in the government's brief to say that they were the same. Government Exhibit 3 at the suppression hearing was a slightly different angle of this, of the magazine, but mind you, it had not been moved. And Government Exhibit 9 at trial, but it's in the same position as it was at the time Officer Strong found it. Officer Strong, and granted, it's trial testimony, but he said that he didn't move the magazine when it was found, and that it was in the position shown in the trial photo when he saw it. So it's, in addition to all of this, you still have the fact that this is a car registered to the defendant. It's sitting with the bullets facing up directly next to the driver's seat. We don't know when he got in that car, but we certainly know that he got out of it. Again, the overhead light would have turned on, and the magazine is sitting right there face up. It's pretty clear that the jury did not accept the defense argument that the gun had been planted, or the magazine had been planted by somebody else, because they did find he was convicted of PLCFD and of the UA offenses at trial. So there's no question that the jury thought that the magazine was his, that it wasn't somebody else's. And additionally, that ties into the sufficiency of the evidence as well. This is, again, he's sitting directly next to the driver's seat. The magazine, as Officer Strong testified at trial, was clearly visible when the car door was opened, which we would argue means the defendant could see it as well. Generally, if the car is yours, it's registered to you, you're the sole occupant, and you're seen by the police in the driver's seat, there would be reason to make a reasonable inference that you're responsible for the items in your car. And I would also point out that we were not trying to conflate constructive possession with what the attributes of an item. Our point was saying that constructive possession is one thing, but we cited a case, Bernard West, which was a vial of PCP that was found out in a car. And West indicated that if something is in plain view, then in a car, that you're also aware of its attributes. So that's why we were citing that case. And granted, that was more of a smell versus a sighting, but we think the same analogy fits here. If this magazine is right next to you and you're getting out of the driver's seat, there's no reason to believe that he did not know it was there, or that it was his. And additionally, in regard to the sufficiency, although he was not convicted of ownership of the gun or possession of the gun that was found under the car across the street, 53% of the DNA on that gun was his. And we don't know why the jury decided not to convict on that charge, but it was not as if there was no gun anywhere that couldn't be tied to him. So that is another reason why there's evidence here that's sufficient to believe that he knew the characteristics and possessed that magazine in his car, particularly when the magazine in that other gun across the street is a 40-round large capacity magazine. Again, almost fully loaded with 39 bullets. And we would definitely say that in regard to both the facts of Bruce's case is very, very different. Bruce, the court stated that the magazine was fully inside the grip of the gun. It was a 12-round magazine as opposed to a 17-round here. And we do not believe that, reading the Bruce decision accurately, it did not hold that as a general matter, capacity is not a visible feature of a gun magazine. And the citations to cases from the Massachusetts courts, when you get into the facts of them, each one, save one that was talking about a capacity issue of quite a small magazine. I believe it was, I'm not sure the number in there, but there are situations like, for instance, in the Cintron case, it was a 13-round magazine, but it was in a closed ammunition box wrapped in a bandana along with a firearm resting on top of a box of bullets. That is not the same as having a gun sitting, or a magazine sitting out with at least 12 visible bullets in it next to the driver's seat of your own car.
So you would be inclined to agree that the evidence of knowledge here would have to be somewhat indirect, like it'd have to be an inference from something else, or as a matter of law, more so than direct evidence that we have in the record.
I'm not understanding. You believe that we would have to have direct evidence of his knowledge?
I'm not saying that we have to have direct evidence. I'm saying you would be inclined to agree based on what you've said, the bases you put out, that we don't really have anything direct in evidence that on its own establishes the knowledge that this is more of a legal determination as a matter of law from the doctrines you've described or inferences.
Correct. And we
Therefore-
believe they're all reasonable inferences, which is fine. And of course, especially in talking about sufficiency, direct evidence versus circumstantial evidence is all equal. And I don't have a case citation off the top of my head, Your Honor, but I'm well aware that this court has said that it's a rare situation where you have direct evidence of somebody's intent or knowledge. And it very often is decided based on the circumstances surrounding the situation. And when you take all the circumstances here, including that there was a woman in the middle of the street yelling that he's got a gun, we believe there's every reason to think that there is sufficient evidence that he knew that that gun was larger than 10 round capacity. And for all these same reasons, we believe that there is no Alano prong 3 or prong 4 problem here in regard to the jury instruction that was given. The same type of evidence, although it's not a sufficiency standard, the same evidence that would support sufficiency here would get us past the third prong of the Alano test. And in addition, this is not a situation where upholding the verdict would impugn the integrity of the court or the judicial proceedings, because this is simply a matter of a situation where the law was one thing. There was no requirement that had been held to exist until the Bruce case, which was decided 8 months after this one. There was no requirement that the government prove that the defendant knew that the capacity was more than 10 rounds. And for that reason, this is a situation where simply acquitting him, reversing the conviction and doing nothing more would actually be the thing that would impugn the integrity of the judicial proceedings. Because given the law at the time, this is a situation where the government did put on proper proof of what was required at the time. And simply to say that every time the law changes, you simply would overturn a conviction that was fairly gained, it would be an improper use of the court's power, we believe. If the court has no further questions, I would like to cede any time I have left to the OAG counsel. Thank you.
Thank you, Ms. Kelly. Mr. Fatak, welcome back to the podium.
Thank you, Your Honor. May it please the court, Ashwin Pathak for the District of Columbia. And as my colleague noted, I'll address the Second Amendment issue today, which the court may not need to reach depending on how it resolves the other issues in this case. But if it does reach that question, I do think that this case is quite a bit different from the Benson case that the court heard back in December, because Mr. Miller is a felon. And not just a felon, but he was convicted of a violent felony, assault with intent to kill while armed. That's at page 105 of the 4th volume of the record. Given that prior violent felony conviction, my friend on the other side suggested it would be a difficult question whether or not Mr. Miller could be disarmed under the Second Amendment. But I don't think that's true at all. And more importantly, they have not made that argument in their reply brief. We made the argument that because he's a felon, he does not have the ability to make this type of Second Amendment argument. In our brief, the United States made it in its brief, and they, in their reply brief, did contest the mode of analysis and said that a felon should be able to challenge this type of large capacity magazine law, but they did not make the argument that a felon with this type of conviction could not be disarmed under the Second Amendment. And I think that accords with all of the precedent that we have right now. In Heller, the court said that those types of, the notion that a felon could be disarmed is presumptively lawful. Obviously, they're going to be borderline cases. You can consider, a mail fraud statute violation from 30 years ago, something non-violent. We don't know the answer to that. The Supreme Court obviously hasn't told us. But as to a violent felony like assault with intent to kill while armed, I don't think anybody has suggested, I'm not aware of any court that has suggested that that type of individual cannot be disarmed under the Second Amendment. And given that premise, the question is then whether a person who can be disarmed as to all firearms and all weapons accessories, including large capacity magazines under the Second Amendment, whether they can come in and challenge a provision under the Second Amendment, given that they can be disarmed under the Second Amendment. And I think, we really think the answer is no to that.
Based on what? Is it a standing question, a constitutional standing question, a prudential standing question, or something else?
So I think it is clearly not it is not Article 3 standing. The person has injury. Obviously, Mr. Miller was convicted and so has harm. No question about that. I think the best way to think about this is really that he doesn't have Second Amendment rights. He doesn't have the ability to assert Second Amendment rights. And I think if you're really kind of getting theoretical about it, what we're saying here is that as applied to his circumstances, he cannot bring this type of challenge, because as applied to him, it is plainly a constitutional application of the large capacity magazine statute, because the district always could have passed a law that said, violent felons are prohibited from possessing large capacity magazines. Nobody would contest that is a lawful use of the district's authority under the Second Amendment. I haven't seen an argument from them that wouldn't be a lawful use of the district's authority under the Second Amendment. And so given that fact, I think his as applied challenge has to fail, because as applied to him, this clearly does not violate the Second Amendment, which then gets us to the facial challenge. And for the facial challenge, I think the problem for him is that one of the applications of the statute is to him a violent felon. And so that is an application that is constitutional under the Second Amendment, which means the facial challenge has to fail as well. And that's what this court has said repeatedly. I mean, in the Ward decision just from last year, I'll just quote directly: for a defendant to bring a Second Amendment challenge in this jurisdiction, he must not be disqualified from the exercise of Second Amendment rights by reason of factors such as criminal history. And then I'd also talk about the Valdez case, which I think is really critical in understanding how facial challenges work. What the court did in that case was it essentially said, as to the sodomy law, which in the vast majority of its applications is unconstitutional after the Supreme Court's decision in Lawrence v. Texas, in the narrow, the slim, narrow area of cases where it's non-consensual sodomy, the government can continue to prosecute under that statute that is unlawful in the vast majority of its applications. And the word non-consensual does not appear in the statute in the same way that the word felon doesn't appear in the large capacity magazine statute. And nevertheless, the court was willing to say, essentially, because there's this one, narrow application of the statute that is permissible, despite the vast majority of applications being impermissible, that is, that prosecution can move forward for a law that, may be overbroad, because the test isn't overbreadth. That's the First Amendment facial challenge test. For all other laws, as the court made clear in the Rahimi decision just last year, even for Second Amendment cases, facial challenges are exceedingly difficult to bring, and you must show that it is unconstitutional in all applications, that there's no permissible application in order to bring that kind of a challenge.
I mean, it seems like then the argument would not be that they're difficult to bring, but that they're completely foreclosed by the fact that they could always be applied against felons.
I think that the logical conclusion of our argument is that, but let me just offer a couple caveats to that. I think you can still bring a categorical challenge to a specific subset of applications of a law. So for instance, if somebody came into court and wasn't a felon and possessed a 17-round magazine, they could obviously bring an as-applied challenge to that 17-round magazine. I think they could also bring a facial challenge as to the category of law-abiding, responsible citizens possessing large capacity magazines. Now, we think there's a problem with that also, because obviously the law applies to 50 and 100-round magazines, and I haven't seen any theory for why those are in any way necessary for self-defense or in common use, et cetera, that gets into the merits of our argument. But putting that point aside, I think you could bring a categorical challenge. It's sort of a meld, I guess, a type of facial challenge to a particular category of applications of the law. I think that has to be true. I think that's honestly what the court did in Heller, the Supreme Court did in Heller, right? As to law-abiding, responsible citizens, it held the district's law in that case to be unconstitutional. Now, if the next day the district had charged a felon under its UF or UA provision, that same law that the court addressed in Heller, that was surely a constitutional application of the statute, because a felon can be disarmed. I think everybody agrees to that. So I think that's how I would think about it. And I agree with you, that is the logical consequence, but I don't think it's sort of a troubling consequence. I think that's just how facial challenges work, that they really are close to impossible to bring, because you do have to show that there are no lawful applications of the statute. The court went to pains to say that in Rahimi, actually, I think, and even in the Net Choice decision, which was a First Amendment case recently, the court has sort of explained how these types of facial challenges work, and has really pushed back on the notion that a facial challenge is just about any particular application. I'm happy to address any questions about the actual merits of the large capacity magazine issue, but I know that the court has another case that's addressing that issue as well, and there's been many arguments that we've made in our brief for why we think we should succeed on that. If not, then thank you very much.
Thank you, Mr. Patak.
Just a few points in rebuttal, Your Honor. First, on the sufficiency of the evidence, I think it's important to remember, right, that the difference here between what is a lawful magazine and what is an unlawful magazine is the difference between 10 and 17 rounds. My friend sort of continues to sort of say that it's 17 is so large, it's so much larger. It's the same size magazine. It's the question of whether there's one row of bullets or two rows of bullets, right? Like this is not an extended magazine. This is not an extra long magazine. This is a magazine that it requires some sort of careful looking to know what separates it from a lawful magazine. And I think sort of some of the arguments rested on, and Judge Howard's questions about sort of shouldn't you be charged with knowing? And again, that is the kind of quasi-strict liability argument that this court rejected in Bruce. Next on.
Sorry, just
Go ahead.
real quick, and I'm not suggesting you did anything wrong in raising that, but is that in the record that the size, the length of a 10-round magazine is the same as a 17?
It's not.
Okay.
No, Your Honor. Second, on the sort of argument about the jury instructions and the plain error and the sort of unfairness under prong 4, I think it's just sort of inaccurate and an inaccurate description of this court's case law to say that an error that affected the jury's verdict under prong 3 can nonetheless be fair under prong 4. Carroll and sort of the cases that Carroll cites are quite clear that if the sort of error in the jury instructions led to a reasonable probability of a different result, that inherently, when the problem is a sort of missing element of a jury instruction, that inherently causes unfairness under prong 4, because the idea is that the conviction is sort of based on a sort of a mistaken apprehension of the law and not enough evidence to make it obvious that the jury nonetheless would have reached the same result. If the error affected the jury's deliberations, then it is unfair under prong 4, even if it's a new requirement. That's sort of why we're in plain error in the first place, right? Like that's why the government had to, or why we had to show that the error was plain. So that's the answer on, or so that's our response on the jury instructions. And then I have a few responses to the district's arguments on the Second Amendment question. So it is sort of difficult to figure out where in the Second Amendment analysis the fact of Mr. Miller's felony conviction goes, if it goes anywhere. I think the thing that I was trying to argue, and I think is fair, that there is no real obvious support for, is this sweeping argument that felons fall outside of the people to whom the Second Amendment even applies at all. I just don't think that that is an open and shut question. I think it's very different to say the Second Amendment applies, but at the second step of the historical analysis, the government might be able to point to tons of examples of historical disenfranchisement of felons. But that's a very different argument than saying that felons categorically fall outside of the people forever. That's not something that the government has sort of presented any substantive evidence to support. That is not something that I'm aware of courts having addressed. And that's just sort of a big, open, hard question. So then the next sort of response I have to what the district argued is that they argue that the district could have passed a law saying that people with felony convictions can't possess large capacity magazines. They probably could have, but they didn't, right? That is not the law we're talking about here. The law that the district has actually passed, under which Mr. Miller was actually convicted, doesn't turn on his felony conviction. It says no one, no matter their criminal history, no matter their mental illness, no matter where they are, can have a magazine that's greater than 10 rounds. And Conley and Valdez make clear that when you're conducting an analysis of a statute, you don't sort of ask, well, could the district have hypothetically written a better statute that would have covered some of this same conduct? That's not the question. You have to look at the actual statute that was actually written and ask whether that is constitutionally permissible. And here his felony conviction is not part of the actual application of the statute. They're sort of picking that fact out of the record and saying, well, that makes it roughly fair, but that's sort of not how we do constitutional challenges. On Valdez, I think the sort of the reading of Valdez is that they had a savings construction of the statute, right? But for the court to sort of save the PLCFD statute for people with felony convictions would require the court to conclude that it's sort of within the judicial function and within sort of consistent with the legislative intent of the statute to adopt this permissible construction. And the government hasn't sort of offered any evidence that that's actually what the legislature would have or did intend, right? And again, this goes back to my point that this is not a statute that is about felons possessing guns or large magazines. This is a statute about anyone possessing any magazine that's larger than 10 rounds. It's not at all obvious that the legislative intent would be served by grafting on a felon sort of exception to this statute. The district has chosen to legislate about felons in a different scheme by prohibiting them from registering any firearms or any ammunition. And this is a different statute that targets the capacity of the
What
magazine.
about the aspects of the legislative history which were explicitly addressed in Bruce? That the real concern about this is it becomes exponentially more dangerous for police officers and others when someone can fire more than 10 rounds, when there's not that 2 to 3 second switch where you have to, get rid of one clip and put another one in. That seems to be explicitly addressed primarily of people that they think are going to get into it with the cops, which entails, while it's not a direct reference to felons, but kind of recidivism and other things, and also people who may not have a conviction at all that may go and get one. It seems like there's at least one interpretation where the city council was squarely aiming in the general direction.
I don't know that I would sort of agree with that reading of the legislative history. And I also don't know that sort of that passing reference in the legislative history is enough for this court to be able to sort of rewrite the statute without intruding on the legislative function, right? Like, I think that it is fair for the legislature to be concerned with anyone having large rounds of ammunition, but that's not tethered to felons. And I think it's, then the Second Amendment merits question is whether that concern is sort of relevant when it's a magazine that is, or a weapon that's possessed by, 200 million Americans.
And along the lines of tethering, 200 million Americans. That seems like it include a lot of kids too. But on lines of tethering and taking you in a different place, and please feel free to come back here afterwards. As I look at the record, it was absent of a lot of things, but there was testimony that the specific gun, a Glock 9mm, fit both the larger extended magazine and the magazine found in the car. What kind of differentiation or what attack on that would you levy to?
Is this sort of on the sufficiency
Yes.
question? So I think that the sort of responses to that are, I agree, it is in the record that the sort of magazine would have fit both guns. But I don't think, so first, I think it's important, sure, the jury could consider that, but it's important to remember the jury acquitted Mr. Miller of that gun. There was no testimony from the police officers who Officer Way saw Mr. Miller walking, testified specifically, I didn't see him walking in a way that suggested he had a gun. I didn't see him drop a gun. I didn't hear him drop a gun. Sort of the only testimony about him having a gun is from the Strouds, who then later recanted on the stand. And the jury acquitted of that. So sort of whatever relevance it has.
And the unnamed woman yelling out, right?
Sure, but she didn't testify. And so that's one response. And the second response is that I actually think in some ways it's sort of not obvious at all that the jury looking at the gun under the car would sort of drawn from that gun the inference that he must have known the capacity of the magazine inside the car, in part because the testimony about the magazine under the other car was that multiple people looked at it and said, wow, gosh, that's really big. And no one said anything about the magazine inside the car. And so it's sort of just as plausible that the jury could have thought, well, he thought that one was big, but this one in the car was perfectly okay. I mean, we just don't know. There's nothing in the record that would allow us to do anything other than make speculative inferences. So.
Sorry, I have one more question. I know we've been going long here. What's your response to the point, I know you briefed it, but the point that the magazine was evidence, so the officers were responding to a report about a gun. I think your response, and the magazine was evidence of that offense, regardless of its capacity. I think your response in your brief touched on sort of the lack of Officer Strong's knowledge of the report of the gunshots. But if we apply the collective knowledge doctrine, what's your response?
I think the response, if you apply the collective knowledge doctrine, is that even a report of a man with a gun is not actually necessarily a probable cause of a crime being committed, right? And I want to make clear the limits. We're not saying that the police can't respond to a 911 call saying there's a man with a gun. I'm not saying that they couldn't conduct a protective frisk if they saw Mr. Miller and they had reason to believe he had a gun. But it's, again, for the same reasons that just seeing a magazine isn't probable cause that it's contraband, just hearing that someone has a gun isn't a probable cause of a crime when, in light of Wren, sort of gun ownership and gun registration is presumptively lawful. There needs to be more evidence to suggest that there's criminal activity afoot. And I just don't think the sheer fact that there is a man with a gun without any testimony that he was threatening people, that he was assaulting people. I just don't think that that is probable cause of criminal activity after Wren and Heller. Thank you. We'd ask this court to reverse.
Thank you, Ms. Halpern. The case is submitted. Thank you both counsel for all three counsel for your arguments today. All right, we'll give the gallery a moment to clear. And for the folks exiting, we'll remind you that if you're discussing out there, we can hear you in the courtroom. All right, we will now call the next matter, number 22-CO-908, G.W.J. v. United States. Counsel ready to proceed? All right. Mr. Thompson, how much time would you like to reserve for rebuttal?
2 minutes, please. Good morning, and may it please the court, Adam Thompson on behalf of the appellant G.W.J. 2 decades ago in Smith and W.M., the Supreme Court and this court analyzed what were then fairly novel sex offender registration laws on the existing record to determine whether, despite their civil public safety intent, their effects amounted to punishment by another name or were so irrational or excessive that they crossed the line into impermissible punishment under the ex post facto clause. Today, the DC Sex Offender Registration Act's regulatory scheme is more restrictive, and the record before this court on juvenile brain science, lower and variable recidivism rates, and the affirmative disability and direct harms of internet notification have significantly changed. This changes the analysis of SORA's necessary operation under the balance of factors in this intense effects test. They now show a punitive effect under this totality of factors because they negate the precise justifications that this court offered in WM in finding that SORA remained on the non-punitive side of the line. Now, SORA's irrationality and excessiveness in its lifetime provisions are illustrated most acutely in cases like G.W.J's, where the regulatory scheme necessarily requires lifetime registration and notification for those who have been found by a neutral judge to be non-dangerous.
Counsel, can I ask you a kind of context question or a global question, how you view the decision from the trial court? I understand much of your argument and I'm quite sympathetic to much of it too. Do you think the trial court really keyed in on some of these questions you're raising versus simply relying on our precedent to end the analysis there?
I think we have to assume that the trial court did. The reasoning, I take your Honor's point that there's not much reasoning there, but you can see, I think, in the trial court's reasoning, a split between, you know, I'm relying on the precedent in WM, and I don't see any changes to, we very strongly disagree on this point, but I think what you can infer from her ruling is that she decided that nothing had really changed to not apply WM in that way. And then secondarily, she went on and found that our claims regarding IRA and the juvenile brain science, that did not move her either. So
Counsel,
I think,
what's your client's position now on whether his claim is a facial challenge, as applied challenge, or a group-based as applied challenge?
Our position is that it is an ex post facto challenge. I think some of the confusion maybe that has been injected by the government's bringing up selling, it really inheres in the nature of the ex post facto analysis, because the court there is analyzing something that can never really be a true facial challenge. You know, we're only able to challenge the retroactive applications of the law. It doesn't really lend itself to a facial analysis in that way. But at the same time, we know from the Supreme Court's precedents that when looking at the law's necessary operation and when looking at whether its effects are cross the line into punitiveness, that you look at the facial aspects of the law. That's in the case law. So we're looking at the law's necessary operation and its facial effects, but we're not per se raising a facial challenge. I mean, what we have raised is a claim that has to do with all of the punitive effects under SORA's necessary operation as felt, you know, in a case like G.W.J's. So, but we're still not raising, similar to selling or similar to Arthur, things that are just applicable to G.W.J.
But
Things that
that's, I mean, but
require-
that is what your client did in the trial court, right?
Well, I would disagree with that. I was counsel in the trial court, and we were very careful not to raise things that required evidence, us to put on evidence, affirmative evidence similar to what would have been required in Arthur to make out, well, Arthur was facing, you know, this losing the ability to live with his mother in her public housing, was losing employment opportunities personally. What we have raised has to do with the effects that are generally felt by people who are subject to SORA. There's nothing about our claim, even the parts that have to do with IRA, that really require that level of fact-finding, and doesn't raise the concerns that the court had in selling about things that are subject to change, things that are subject to the vagaries of implementation. Everything that we have raised that that has to do with something as a sort of subclass of people who are subject to SORA, they all depend on the facial operation of the statute. And that's, so to illustrate this, we've only really challenged lifetime registration as punitive. The government is not saying that we can't bring that constitutes the kind of as applied challenge that is subject to selling. So similarly, the aspects that apply to IRA grantees, SORA necessarily does not make an exception for them, necessarily does not care whether they have been found dangerous, doesn't care about the categorical and unconditional evidence of their lesser culpability and greater capacity for
But it does in a certain
rehabilitation.
sense, doesn't it? In the sense that it doesn't apply to folks with juvenile convictions, just ones who were tried as adults and have the more serious conviction, right?
That's true. That's the way it works.
Does that narrow down the class of people significantly that this applies to? The challenge that you're bringing?
Well, there's nothing that I don't think that answers the question that we've raised. It does narrow somewhat the application of SORA to people who were under 18 at the time that they committed their crime, but the charging decisions of the United States Attorney don't really answer our claim that SORA's irrationality and excessiveness are very clearly illustrated by somebody who has been found by a neutral, detached judge under very robust adversarial procedures to be non-dangerous. So one thing that I think sets apart where we are now, the record, from where things were at the time of WM, is that this court has decided felon and has recognized that that internet notification is an affirmative disability or restraint, which puts all of the panoply of harms that flow from registration in a distinct way. It puts them on the side of the punitive side of things. This court, unlike in WM, would be considering those things to be both affirmative disabilities and restraints, and to be adding to the resemblance of this law to public shaming.
But we made clear in Fallon and in Hickerson that that analysis pertained only to the Sixth Amendment side of this and not the ex post facto clause.
That's true that that is the legal nature of Fallon, that it's a Sixth Amendment challenge, but there's nothing about the differences between that legal analysis and the ex post facto analysis that would change the relevance of the more factually oriented nature
But I mean, it's
of the
not just that,
premise.
it's not just that Fallon happened to be a Sixth Amendment case. We actually addressed this in Fallon explicitly, right? I mean, we said, nothing we say here, and I'm paraphrasing, but we said it again in Hickerson, that the analysis just doesn't translate to the ex post facto side. So even if, so I mean, saying that it's the factual bases underlying the Fallon's analysis with respect to the Sixth Amendment should carry across just seems like an end run around that whole point, that the analyses are different under the two constitutional provisions.
Well, what we're asking the court to do here is to do what it did in Fallon. We're not saying that there is some direct legal line from Fallon to here, but what we have presented the same extensive social science that is again unchallenged by the government, and we're asking the court to reach the same conclusion that it did in Fallon.
So
which
then
is-
that would require, I mean, that would run headlong into Hickerson and Arthur, right? I mean, then you've got a sort of foreclosed situation where this panel can't overrule those two cases.
Well, I disagree that Arthur and Hickerson decided anything like this. There was no extensive social science unchallenged by the government on this point in the record in Arthur or Hickerson. There were some recidivism studies raised in Arthur that all, again, predated WM, as the court says, but I don't believe any of the studies that we cite, that are cited by the court in Fallon, that were vetted by the court in Fallon, I don't think any of those were in the record in Arthur or Hickerson. And so there's nothing about those cases that forecloses this court from doing what it did in Fallon, which is read these studies and come to that conclusion. And it's an unchallenged record from the government. In fact, the government concedes that Fallon, they say, departs from WM on this very point, which I think is a pretty important concession.
Were the studies you're mentioning on the record before the trial court?
Yes, they were.
Which brings me back to my original question before, that I was just reading the ruling for the 9th or 10th time here. And do you really concede that it addresses those and shows full consideration of that point?
Again, I don't think we don't typically parse, I think, sort of, I wouldn't call it a summary ruling, but it is something that the court, I think we have to presume that she read everything that we put before her and that her ruling took that into consideration. I don't know that there's anything in her order that says she didn't consider that. And there's every reason to think that, look, I mean, we in some ways are going up against a 20-year-old precedent that most Superior Court judges, I think, would not feel like they could go behind, and maybe did not understand the level of difference in the record.
Would you agree that NRA WM invites court to go behind it, noting specifically in there that the regulations and law may change, the evidence supporting this may change, et cetera?
Yes, I think it does. And I think that's what this court recognized in Arthur by saying that when there is changes to SORA's necessary operation, that when there's new evidence of that and when there are changes to the actual regulatory scheme, that invites the court to take another look at what it decided then. And it is clear when you go back and look at Smith and WM, how much of what was decided there was bound up in the record that was actually before the court. I mean, on the point of the point that Fallon addresses, Smith says, well, it was pure conjecture that there's a direct line from registration to these harms, as opposed to flowing from the conviction itself. The court says in Smith, we didn't have any record to show that was the case. Well, that's not the case here. This record is very different. If there are no further questions, I'll reserve
All right.
my time for rebuttal.
We'll add your extra minute to your time on rebuttal.
May it please the court, Timothy Cahill for the United States. At the outset, I wanted to indicate that we will be sharing our time 10 minutes for the United States and allotting 5 minutes for the Office of the Attorney General interveners. Your Honors, the trial court correctly rejected appellant's constitutional challenge to SORA, and I want to begin with addressing the distinctions between facial and as-applied challenges, because while it's true that in some contexts, for example, the First Amendment context, the Supreme Court has indicated that there is some overlap there. In the specific context we have here of ex post facto claims, both the Supreme Court and this court have recognized those as very distinct types of claims and have applied different types of rules and requirements for them. And as we outlined in our brief, we submit that any sort of facial claim here was not just forfeited below, but was affirmatively waived below. Appellant affirmatively argued below that it wasn't a facial claim and therefore wasn't foreclosed by WM and Arthur because it was only an as-applied claim. But even if this court were to reach the merits of a facial claim, we submit that the appellants have misstated and overstated any sort of changes, any sort of what Arthur called would require dramatic or marked changes, either to the necessary operation of SORA or to the effects of SORA, that would warrant reaching a different outcome than was reached in WM and Arthur, which I would note, appellants keep saying 20 years ago for WM. I would note that Arthur rejected some very similar claims that are brought in this case less than 4 years ago. That's much more recent binding authority. I did also want to address with respect to the effects of internet notification and what Fallon had to say. There is it's not just that Fallon sort of set aside ex post facto as different. It explained why, and it's clear in the nature of the analysis under the Martina-Mendoza's factors why it's a different analysis. In Fallon, under the Sixth Amendment analysis, the court was only looking at whether or not there was a sufficient penalty to consider that to show a legislative intent to consider it a serious offense. There was no consideration of the fourth and fifth Martina-Mendoza's factors, which courts have consistently identified as the most important factors in this analysis, which is the rational connection to a non-punitive purpose and whether in an excessive analysis with regard to that connection. And that's exactly the factor on which WM found that internet notification in fact weighed in favor of SORA being non-punitive because it was so deeply connected to its underlying policy purpose of making sure that members of the public had factually accurate information about sex offenders who might be living in their community. And
so let me press you along those lines, the same question I press to your friend across the podium from you. If those factors are so important and so key, what is your position on assuming we buy the stance that all of this evidence was presented and those kind of factors are really challenged at the trial court? Do you think the trial court really engaged in some sort of analysis around that, or did it simply sign off to precedent?
I think somewhere in between those, Your Honor. The way I read the trial court's analysis is not simply signing off to precedent, but taking the precedent as its starting point, as is appropriate in a case like this. It wasn't writing on a blank slate. WM and Arthur are binding precedent, on this panel and below. And so while Arthur recognized that dramatic and marked changes could, in some circumstance, warrant revisiting those decisions, that's what needs to happen. The appellant needs to have established a record of establishing that level of change. And I read the trial court as rejecting that they satisfied that. It didn't feel the need to reinvent WM and Arthur's application of all of the Martina Mendoza's factors, that's binding law. But it said that there's nothing sufficiently new here or sufficiently different here to warrant reaching the opposite outcome on the question of constitutional punishment, which requires what the Supreme Court's called the clearest proof of negating the legislative intent.
What about those in-person check-ins for life? That feels pretty major.
So, Your Honor, I did want to, of course, address that. And so that's with respect to the quarterly in-person updates. That is something that was, I think, added in 2022. So a couple of things. One, I would note that in Arthur, the actual appellant in Arthur was himself subject to quarterly in-person check-ins. He raised that as something that was punitive, or his claim was that that was punitive constitutionally. And the court in Arthur rejected that, saying that that was not sufficiently excessive or an abuse of authority by CSOSA to be sufficient restraint on his liberty as to be constitutionally punitive. I would also emphasize that SORNA, the federal statute, sex offender registry, unlike SORA prior to 2022, which we can see, acknowledge only required that schedule in certain circumstances, and it now is required for all Class A and Class B offenders. The federal SORNA statute does require it for all offenders at the highest level under SORNA, and federal courts have consistently rejected challenges to SORNA as being punitive, and indeed claims based upon that very requirement. I would point to the Parks decision from the First Circuit, which expressly addressed the quarterly in-person check-ins and acknowledged that there is certainly more inconvenience to requiring someone to come to an office in person than there would be for a telephone or a mail requirement. But they said that didn't rise to the level of constitutional punishment. And they especially emphasized that it served the non-punitive purposes of the registry of the statute in multiple ways. It guaranteed that the individual was still in the vicinity, was still in the jurisdiction in a way that sort of a remote check-in would not. It allowed an opportunity to confirm their identity by fingerprints, that they actually were the person who was confirming the registration information, and also guaranteed that any dramatic changes in the individual's appearance would be caught immediately. It would not rely upon purely on self-reporting. And so for all of those reasons, in the federal context with the exact same requirement, they shot down an ex post facto claim based on that, saying that that did not rise to the level of constitutional punishment. On a similar note, in terms of the appellant's reliance on other purported changes to SORA, we did want to emphasize that this purported twice annual home visits requirement is actually not mandated under SORA. We submit that that's actually clear on the plain face of the statute. I can also, I understand it's not in the record, represent that CSOSA's sex offender unit does not understand the statute that way and typically relies on the mere mailing of deeds or leases to verify home address verifications. But on just looking on the record, even not even on the record, at the face of the statute, appellant's claim here seems to be based on an erroneous conflation of the word verification and the word visit. The verification is what's required twice annually in terms of verifying a home address. The regulations explain how that verification can be done and say one way that is permissible is a home visit. But there's also indications that it can be done by mailing, returning address verification forms by mail. And it's appellant's burden to demonstrate that it's the necessary operation of SORA that would be punitive. And there's been no evidence of any abuse in either the frequency or the nature of CSOSA's discretion to conduct home visits when they feel like it's necessary. In fact, below, appellant purported to identify examples of some sort of abuse in this regard and erroneously relied on examples that only involved individuals who were on court supervision while still serving their criminal sentences on probation or on supervised release, where, for example, their homes might be searched. And there's, of course, abundant case law about the differences in expectations of privacy for people still serving criminal sentences. Appellant below it did not establish any record of any that sort of procedure and regulation by CSOSA with respect to people who are in the registry but no longer serving their sentences. And of course, it's their burden to do so, to establish by the clearest proof anything that would rise to the level of being punitive for constitutional purposes. I did also want to address, to the extent appellant relies on data involving juveniles and relies on the IRIA, those would have no bearing on a facial challenge. They would only have a bearing on an as-applied challenge. And we submit that, as this court noted in Hickerson, this court acknowledged it was legally an open question, but indicated that there is certainly significant doubt as to whether or not an as-applied challenge, even what has been described as a group as-applied challenge, could be viable post-sailing and while WM and Arthur remain good law in this jurisdiction. And we believe that that's consistent with this court's recognition and the Supreme Court's recognition that with respect to ex post facto claims, legislators are entitled to make reasonable categorical judgments. In fact, WM, recognized what seems like an obvious truth, which is that some offenders will be able to rehabilitate themselves, offenders of any who've committed any type of crime. But that doesn't negate the council's intent to have a regulatory scheme here. And as we cited in our brief, while there are conflicting social studies, we acknowledge that there's not a uniform voice among social scientists on this issue. There is robust evidence that sex offenders, including juvenile sex offenders, recidivate at a significantly higher rate than those who commit other types of crimes. And in the Supreme Court in Kebido, looking at a challenge to a federal sex offender law, said Congress was certainly entitled to make reasonable decisions, categorical decisions about sex offenders based upon that data, and that's a legislative policy decision that courts shouldn't second guess. There are no further questions for me. I would ask that the judgment of the trial court be affirmed and turn over to the intervener counsel.
Mr. Mendez, we have you for 5 minutes.
Good morning, Your Honors. May it please the court. Chris Mendez on behalf of the District of Columbia. On appeal, appellant raises a facial as well as an as-applied ex post facto challenge. Both fail. First, appellant forfeited his facial ex post facto challenge by failing to raise it in a trial court. Even if this court were to consider the merits of appellant's facial challenge, it is contrary to binding precedent from the Supreme Court in Smith, as well as from this court in WM and Arthur. And the so-called new developments that appellant relies on come nowhere close to showing by the clearest proof that SORA is punitive in all of its applications. Second, appellant's as-applied challenge also fails. Selling in Arthur foreclose any individual as-applied ex post facto challenge, and this court should now make clear that the supposed group-based challenge is equally non-viable. Appellant's arguments are ultimately an attack on the DC Council's policy judgment about how to best ensure public safety. But a policy disagreement cannot undermine the constitutionality of SORA. With respect to the facial ex post facto claim, I wanted to begin with this forfeiture by appellant's failure to preserve that argument down below. In the trial court proceedings, appellant tailored his claim to children, for the most part to children convicted of sex offenses, and in other instances, appellant tailored his claim to individuals convicted of sex offenses as juvenile offenders and then subsequently were adjudicated non-dangerous. In his reply in the trial court proceedings below, appellant even appeared to reject the notion that his claim encompassed a facial component. This is not a mere labeling issue, as appellant suggests in his reply brief before this court. To the contrary, he did not argue that SORA violates the ex post facto clause in all of its applications. As a result, the trial court correctly understood appellant's claim to be an as-applied challenge. As a result of all of this, civil forfeiture principles apply here, given that the underlying CSOSA registration order that appellant is challenging before this court is a civil order, and therefore this court should bypass review of the unpreserved facial claim. If this court were inclined to address the merits of appellant's ex post facto challenge, it still falls short. Appellant relies on a variety of so-called new developments to further his claims, but none are persuasive. To begin, with respect to internet notification and recidivism data that appellant relies on, these two so-called changes are neither has anything to do with SORA's actual statutory language or statutory provisions or its implementing regulations. Of course, internet notification has been a part of the scheme since SORA's enactment in the year 2000. And of course, the internet was already commonplace when this argument was considered with respect to the Alaska statute in Smith by the Supreme Court, as well as when this court considered this very question in WM. The Supreme Court's conclusion with respect to internet notification remains true today. And that is that any stigma or humiliation associated with the online registry does not come from any punitive nature of SORA. It comes from the fact of conviction. And that is not a sufficient basis, much less the clearest proof which is required to sustain appellant's challenge here today. With respect to the recidivism data that appellant takes issue with, it played a minimal role in the Supreme Court's ex post facto inquiry in Smith, as well as this court's ex post facto inquiry in WM. And of course, studies pointing to or suggesting the potential for low recidivism rates for sex offenders, that is not a new phenomenon. And it doesn't change the Supreme Court's ultimate conclusion in Smith, which is that a legislative body's decision, here of course that would be the DC Council, to make a categorical judgment based on the fact of conviction does not violate the ex post facto clause.
So, counsel, let me go back to something you said sort of in your intro, which is this court should make clear now that the group-based as-applied challenge is not, I think you said, viable here. Is it your position that we should say that there is no such thing as a group-based as-applied challenge, or just that it fails on the particular facts and claims and circumstances here?
At the outset, the answer is yes to the former. That is that it is not such a thing. Group-based challenges, the Supreme Court in Selling, they didn't explicitly take on the issue of group-based challenges, but it generally dealt with the viability of as-applied challenges. Challenges once the highest court in jurisdiction, of course, that would be this court, here has definitively construed the statute at issue as civil. That is precisely the situation we are here. And the issue with group-based challenges could be is a tension that is based on the fundamental nature of the ex post facto inquiry. The ex post facto inquiry revolves around legislative intent. And that's step one. And then as step two, with respect to the effects test, the foundation of that effects test is ultimately the statute on its face, what the statutory provisions say. And there would be a significant amount of tension if we were to be in a situation in which this court, given this precedent, were to continue to determine that a facial challenge is not viable because SORA is civil, but then at the same time, somehow there is a legislative intent that is somehow punitive with respect to specific groups. That would not be workable, as the Supreme Court recognized in Selling. I do acknowledge, of course, that that is an open question in its jurisdiction. The court in Arthur denied the notion of a specific group-based challenge there based on the facts in that case. Hickerson did the same, but the court in Hickerson seemed to come very close to saying that these are not viable. In fact, the court in Hickerson even characterized the Supreme Court's ultimate determination with respect to this question as suggesting that it is not viable in just jurisdiction. Of course, I don't want to overstate it. The court in Hickerson didn't definitely rule on it. And that is why our position today is that this court should close that door that was left open in Arthur and Hickerson and conclude that group-based challenges are not viable here, where there is binding precedent from this court that definitively construes SORA as civil. And with respect to this group-based challenge, I know in appellant's reply brief, he makes a variety of claims with respect to this. One that I wanted to take on is his argument in the reply that Selling somehow doesn't apply here. And that is not the case. I want to push back on that notion. Appellant doesn't point to any changes to SORA's statutory provisions itself. And as I mentioned, that is a key point when it comes to the inquiry of SORA that revolves around the statute on its face. And of course, in Selling, the Supreme Court rejected the notion that an as-applied challenge could be based on, quote, the implementation of the authorizing statute, at best, at absolute best, and I agree with the United States government's position with respect to the 2022 policy and the 23 regulation. But even if we were to take appellant's claims at face value, those at best are suggestions of very marginal changes to the implementation of SORA. But as the Supreme Court made clear, that cannot be a basis for an as-applied challenge. And ultimately, this case boils down to a policy disagreement between appellate and the DC Council in enacting the SORA statutory scheme that it enacted. But this policy disagreement should not be the basis to strike down the DC's considered judgment in enacting a statute that is meant to ensure public safety. The DC Council, as the policy-making body in the district, is ultimately the body that is best situated to make these types of policy determinations. And what I recognize is a difficult area to law with evidence that is challenging, and in this very serious area of the law, in the sense that sexual crimes are very serious offenses. But ultimately, the policy disagreement and the disagreement with respect to the council's policy judgment, that is best taken to the DC Council. If your honors have no further questions, the district respectfully requests that this court affirm the Superior Court's order. Thank you.
Thank you, Mr. Mendez. Mr. Thompson?
Thank you. I'll begin by addressing this idea that we have somehow both waived and now tried to raise a facial challenge. So first of all, everything that we have raised as far as SORA's necessary operation, we put before the trial court. It is a fact of the way SORA operates that some of the punitive aspects that G.W.J. experiences, other classes of people under the statute also experience. We raised internet notification, we raised SORA being more restrictive. All of those things were put in front of the trial court, and the idea that this court cannot consider those in the totality of the factors under the Mendoza-Martinez test doesn't make any sense. So we have raised, as I said in my opening argument, we have raised an ex post facto challenge. There are various cases, including ones the government cites, Guire versus Marshall comes to mind, that talk about the lack of alignment between an ex post facto challenge and a facial challenge. It just doesn't map on exactly. What we have raised is a claim that under the Mendoza-Martinez factors raises all of the points of SORA's necessary operation that this court should consider under the ex post facto punishment analysis. And that is no different in the trial court as it is here. With respect to selling and whether this is an as applied challenge, Arthur sort of answers this and actually answers both of these questions. The appellant, similar to us, raised aspects that the court characterized as being more facial and others as being more as applied. It addressed both of them, finding that, again, that these labels don't really fit here. But the reason we are not in the same case as Arthur is that the aspects that we've raised are not just specific to G.W.J. They do cover SORA's necessary operation. SORA necessarily makes no exception for people who have been found not dangerous. It makes no exception for IRA or for any other similar adjudication of non-dangerousness. It makes no exception for the same evidence and as this court has held unconditional hallmarks of youth that apply to an IRA grantee here.
But by making no exception, isn't your argument then that it would not be punitive and therefore not an ex post facto violation with respect to people who wouldn't fall under the exception that you say is not there?
Well, our holding that we're asking for is the relief that we asked for in the brief, but we recognize which sort of stops before you get to, or can stop before you get to considering IRA and those sorts of things. We continue to think and argue that SORA's restrictive registration requirements that are similar to probation, its internet notification that is similar to shaming, and its lack of any, its lifetime application without any exception for people who may be demonstrably non-dangerous for whatever reason, not just for the IRA and the legislative findings that accompany it. But because we raise also issues that have to do with IRA, the court could issue a holding that does focus on those aspects of SORA's necessary operation. And there it would be a more limited holding in that respect.
I think there's a lot of logical appeal to the point you make that in one scenario, we've got recognition of someone's youth and how that could affect their potential for dangerousness and other things later through IRA. And someone gets the benefit of that. And then in this context, we don't have that at all. And so similar to what your opposing counsel, Mr. Mendez, brought up a moment ago, why shouldn't we view that as city council passed both of those acts? Why shouldn't we view that as a policy decision that they made, that they should be the ones to deal with instead of us?
Well, I think you shouldn't view it that way because the Mendoza-Martinez factors require this court to look at whether the statutory scheme is rational and excessive. And in that context, it reveals SORA's utter irrationality and excessiveness, which the government in their argument just conceded are kind of in tandem, the most important inquiries here. And in the case of IRA and G.W.J, you have somebody who has two layers of non-dangerousness, essentially. You have the categorical evidence that went into the IRA procedure, the IRA legislation, that these hallmark features of youth lead people to be less culpable and more amenable to rehabilitation. Then you also have, for G.W.J and those other IRA grantees, you have the actual finding by a judge who has looked at all the evidence under the very comprehensive factors and decided this person is not dangerous. And that is fundamentally irrational and excessive when we can and have these procedures for determining that somebody is not dangerous. For SORA to just completely discount that and to make people show up 4 times a year for the rest of their life to whatever process CSOSA uses to verify. I don't think they're requiring people to send in their lease twice a year when they've already sent one in, but this regulation requires them to do something twice a year. And that could be visits, it could be some sort of affirmative action that CSOSA takes. But if it's just sending in a lease, I don't think that's covered under this regulation, but it's required for the rest of their life. And when you consider the burdens of internet notification, the shaming that goes along with it for somebody who is not only categorically less likely to be dangerous, who has been affirmatively found not dangerous, it just is fundamentally irrational and excessive.
Thank
Thank
you
you.
Thank you to all counsel for arguments in this case. The case is submitted. We'll next hear argument in cases 20 CO 728 and 23 CO 724. Ms. Wang?
May it please the court, Alice Wang on behalf of appellant CP. I intend to reserve 3 minutes for rebuttal. I'd like to focus on our constitutional challenge to Mr. P's sodomy conviction, but I'm also prepared to answer any questions about our challenge to the order of sex offender registration. This court has already held in Valdez that the district's former sodomy statute was unconstitutionally overbroad because it criminalized all acts of sodomy regardless of the circumstances. Now the question is one of remedy. Can this court, consistent with the legislative design and the limits of the judicial function, save the statute's application to consensual public sodomy the way it did with non-consensual sodomy in Valdez? And if so, can the court uphold Mr. P's conviction under that saving construction of the statute? The answer to those questions is no. First, unlike the dividing line between consensual and non-consensual sodomy, the dividing line between private and public sodomy is unclear, both in terms of what conduct can be prescribed and in terms of what conduct the legislature would want to keep prescribing under the sodomy statute. Drawing that line is what the Supreme Court in Ayat called a, quote, inherently complex task in a, quote, murky constitutional context that impermissibly invades the legislative domain.
But are we supposed to conduct this AOT analysis every single time someone brings a new challenge to a statute? Or didn't we already decide in Valdez that the statute does not, it's unconstitutional in some respects, but we concluded there that our reading of the legislative intent at the time the legislature passed the statute would be that the statute should not be struck down in its entirety. And isn't that the end of the story at that point?
I think that Ayat asks the court to first separate the valid from the invalid applications of the statute. And then the court must next ask, would the legislature have preferred to keep what is left of its statute to no statute at all? And what Valdez did was to separate non-consensual from consensual sex and said, and it only looked at whether the legislature would have preferred to keep applying the statute to non-consensual sex. And it said, obviously it would. And in fact, that is because historically legislatures have always treated non-consensual sex of any kind, whether it's sodomy or vaginal sex. Sexual assaults have been serious felonies always. And so of course, if faced with the idea that someone committed non-consensual sodomy the way that Mr. Valdez was actually convicted for because the jury was instructed on that element, then that the legislature would want to keep applying the sodomy statute to non-consensual sex. And indeed, that observation was confirmed by the fact that in 1993, when the DC Council was faced with the prospect that, or sort of realized that the sodomy statute was overbroad and violated the right to privacy, it chose to remedy that overbreadth by narrowing the statute to only non-consensual sodomy. It chose to exempt all consensual sodomy, including sodomy committed outside the home, in public, or any other place. And so, Valdez simply didn't engage in the legislative intent question as applied to public consensual sodomy. It only addressed that question with respect to non-consensual sodomy.
Well, I'm not sure it chose to exempt public sodomy from the reach of the statute. It was just silent on the question. And we've got a long history of case law that says that public sexual conduct, whether it's sodomy or otherwise, is constitutionally prescribed, right? Proscribed.
I have two answers to that. I think the council did, in fact, what it did was it exempted all consensual sodomy from the statute. It said no act that is committed by consenting, like the exact, I don't have the exact language before me, but it basically said if it's a consensual act, it's not going to be prescribed under the sodomy statute. And that's true regardless of whether it was public or private. So if the jury did not find that Mr. P committed non-consensual sodomy, which it didn't, then in 1993, it would not be a crime. So it did, in fact, exempt all consensual sodomy from the scope of the sodomy statute. And it had good reason to, because, and again, this sort of highlights why this is a policy decision that this court shouldn't be making. There's two reasons. One is that obviously the harm to the public interest caused by non-consensual sex of any kind, sexual assaults, is huge. And that's why historically it's always been treated as a very serious felony. The harm to the public that's caused by consensual sex committed in public, whatever that word means, is much more minor. And it sort of depends on where it's done and sort of how much an open view it is. And it's always been treated as a very minor misdemeanor, if a crime at all. It's been prosecuted under the indecent exposure, the disorderly conduct statute, or under the more recently under the indecent exposure statute, both of which are punishable by only 90 days in jail. So the legislature has looked at the two harms that are caused by these two types of sex and have said, they're very different. We treat them differently. We punish them differently. And the only reason that they were lumped together under the sodomy statute was because in 1948, when Congress enacted that statute, it viewed the very act of sodomy as an unnatural and perverted act. That's the language that it used in the statute to describe how the offense should be indicted. And Lawrence has now said the legislature cannot, that's not a valid basis to criminalize a sexual act. The legislature's moral judgment about that type of sexual practice is not a valid constitutional basis. And the government should not be invading this sphere of personal autonomy about sexual choices without absent injury to a person or to an institution the government protects. And so now, if a legislature knows now that it cannot ban all sodomy because it's an unnatural and perverted act, then there's actually no reason why that this court can conclude with confidence that the legislature would want to continue punishing both types of acts under the sodomy statute, which is a 10-year felony. And in fact, it didn't. Again, when in 1993, the DC Council had two goals. One was to reform the sodomy statute to comply with the Constitution to protect the right to privacy. And two was to reduce discrimination. And it had before it a record where the sodomy statute's application to consensual sex outside the home was being discriminatorily enforced against gay men. If you look at Harris, Buck, and every other case, Stewart, McKean, every other case the government cites, it's all prosecutions against gay men. And the council wanted to reduce, that was one of its goals, its policy goals, was to reduce discrimination. So even though it believed that it was constitutionally valid to prohibit consensual sex in public, because Harris and Buck said at that time that it chose not to. It did not create a carve out to say, oh, we're gonna, exempt all consensual sex except for that in public. It did not do that. It actually left after 1993, and between 1993 and 2011, it was not a crime to have sex in public, whether it's sodomy or not, or vaginal sex. It was only until 2011 when the council amended the indecent exposure statute to ban sex in public, punishable by only 90 days in jail. And even then, only when in open view and before the public at large, that act, that consensual public sex was even criminalized specifically.
But I mean, we're looking at it's an unfortunate circumstance of sort of the case law. And I agree with you that at the time the statute was passed, there were certainly questionable at best reasons for passing it. But aren't we supposed to look at the perspective of the legislature at the time the statute was passed?
Yeah. The IOT test would make no sense if that's what you were to look at, because of course, in 1948, Congress wanted to ban as much sodomy as possible. It wanted to ban all sodomy because it viewed it as unnatural and perverted. The IOT test is one not about sort of a historical fact of original legislative intent. The IOT test is one about making sure that the judicial remedy is legitimate. And the question is, if the legislature understood that it could no longer ban all sodomy, as an unnatural perverted act, would it want to continue using the sodomy statute to punish public consensual sodomy? Because that is what sort of tests this court to see if its judicial remedy is consistent with legislative intent. And by the way, I would also say that the Ayotte test and the Ayotte and Conley, it's not just about discerning legislative intent. It's actually also about the judicial function. And that's one thing I haven't gotten to talk about yet, which is, separating non-consensual from consensual sex is an easy thing because it's a concept that exists in the law and it's clear. What does public sex mean when you're talking about drawing that line between criminal and innocent sex? Is it
a question that relates to that when you're getting to it? Whom should decide what is public or private?
And that's exactly what I'm saying. That's a legislative job. So in Tilley, I think this case is very analogous to Tilley, where the court held that the Sexual Psychopath Act was unconstitutional because it authorized indefinite civil commitment without requiring proof of any mental disorder. And this court said that it cannot just simply read that requirement of a mental disorder into the statute to say that, because doing so would require, quote, making difficult policy choices regarding such matters as what kinds of mental disorder and type of impairment must be found to justify civil commitment. And we submit that the same thing is true here, that drawing the line between public and private sex requires making difficult policy choices about, what kinds of public conduct can and should be proscribed under the sodomy statute. Is it any sex that occurs outside the home, the way that Buck said? Is it any sex that occurs in a place accessible to the public, as the trial court in 1979 said, or 1980 said? Is it in open view before the people at large, as the DC Council said when it enacted the 2011 amendment to the Indecent Exposure Act statute? These are all possibilities, and these are policy choices. And the reason they're policy choices is because in drawing that line, the council's deciding, or the legislature should be deciding, how much public harm is caused by each of these types of acts. And that's where we're going to draw the line. And not just sort of to make it a crime, but to justify punishing it as a 10-year felony under the sodomy statute. That's not a job that this court is equipped to do. Would invade the legislative function the way that the court said in Tilley it would do, to define the mental disorders that justify indefinite civil commitment. For this court to decide what counts as public that would justify punishing it as a 10-year felony under the sodomy statute, that is a quintessentially legislative decision. So it's not within the judicial function.
But the legislature hadn't made a decision at the time that this case was there. And so to the extent you're asking us to consider the non-public nature of it, there has to be a decision on the record in this case in some way, right? I mean, you're asking us you're essentially asking us to say this is non-public, aren't you?
No, we're asking this court to say that it can't draw the line for itself because that's a legislative function. Just like in Tilley, the court said, Tilley did not say, oh, Mr. Tilley's, particular circumstances are ones that would or wouldn't allow him to be committed under a constitutional version of the statute. What Tilley said is, saving this statute requires us to do the types of things that only a legislature can do, which is to draw the line between public and private. And if it's the type of line drawing that what Ayotte said was inherently complex in a murky constitutional context, that tells this court that that's not the type of thing this court should be doing in order to save applications of the statute. And what's more, the reason we bring up what happened, what the council did in 1993 is to illustrate the many good reasons why a legislature would not necessarily want to continue punishing as much sodomy as possible when there may be good policy reasons not to. And so we have sort of two pieces that tell this court that it should not be trying to save that application of the statute. One is that it requires the type of line drawing that is sort of inherently too complex and policy driven for a court to do. And two, that it actually would thwart legislative intent in that later when the legislature realized that its statute was overbroad, it chose to narrow it in a particular way that did not include consensual public sodomy. And then a point that I haven't gotten to yet, which is that even if this court could save the statute's application to public consensual sodomy consistent with legislative intent and the judicial role, it still couldn't uphold Mr. P's conviction under that narrowing construction because the jury wasn't, unlike in Valdez, the jury wasn't instructed on a narrowed definition of sodomy. And the government really hasn't disputed that point. It really just rests on the notion that Harris and Buck cases that were decided 30 years before Lawrence, sort of predicted or suggested that any constitutional right that would cover sodomy would end at the home. And, for the reasons that we stated in our reply brief, we think that is untenable. Those cases, first of all, is not really a true holding because those cases were decided without the benefit of Lawrence. And so the judicial mind never passed on the scope of the right recognized in Lawrence because obviously Lawrence hadn't been decided yet. But and moreover, Harris and Buck did not purport to save the sodomy statute with a narrowing construction because it didn't think it was unconstitutional. And so the judicial mind, again, never passed on whether the legislature would want the court to save the statute's application to consensual sodomy outside the home.
But that failure to instruct would be subject to Nader harmlessness analysis, right? And so here, I mean, I get that there's some, fine distinctions between how public this was. But for example, if this sodomy had occurred in the middle of DuPont Circle in the middle of the day, wouldn't we be able to find that instructional error harmless?
I mean, the problem with that is that it would require this court to answer the difficult constitutional and policy question of what public means, of course, right? So if this court were to sort of reach the same decision as Harris and Buck and say public means anything outside the home, I agree, it would be harmless.
Well,
it was unquestionably outside the home.
We wouldn't have to do that across all cases. We would just have to do it in this case, right? Because we're determining whether there was reversible error under the facts here, and we're applying kind of a standard harmlessness analysis. And on these facts, those facts, my hypothetical facts, public, daytime, middle, busy intersection, we would be able to do that without having to draw all the lines in all circumstances, right?
I think that would be right, but it would also still have to go through the IOT analysis first, because it's sort of only when you have a narrowing construction can you then look to see if the failure to instruct on that narrowing construction was harmless. And so sort of, I've been focusing my argument on why this court can't get there under the IOT analysis in the first place, because where you draw the line at public is a policy choice. And the council, when faced with the unconstitutionality of the statute, chose not to punish any consensual sodomy, regardless of where it was under the sodomy statute, because it's not, it is not the same thing as in Valdez, where this court looked at non-consensual sodomy, where there was absolutely no dispute that it's not constitutionally protected. The line is clear. We know what consensual means. We know what non-consensual means. And we also know that historically the legislature has always punished non-consensual sex, regardless of what kind of sex, as a very, very serious felony. It would be strange. It would be, I think it would thwart legislative intent, and it would be an overstep of the judicial role for this court to say that just because Mr. P's conduct occurred prior to 1993, that it's a 10-year felony, but anything between 1993 and 2011 wasn't a crime at all. And then after 2011, it was a 90-day misdemeanor. I mean, that kind of, there's sort of an irrationality to that kind of thinking. And that you just don't think, it's not that this court can't be confident that the legislature would want that. the court was confident in Valdez that the legislature would want non-consensual sodomy, even if you take away sort of the unnatural and perverted aspect of it. If it's non-consensual, the legislature would want to punish that as a serious felony. It always has. And even after it repealed the sodomy statute in the 1995 Anti-Sexual Abuse Act, it said, okay, sex is sex. And if it's forcible, it's punished this way. If it's, but it did not do the same thing with consensual public sex.
Can we get to how we get here in the first place, given the procedural bars that play? I mean, there's two, there's successive motions and the abuse of the writ. I'd like to focus on abuse of the writ at least first. I understand your responses to be both that the trial court didn't rely on it and that CP was unrepresented at the time he filed his first 23-110 motion. Is that right?
No, with respect to abuse of the writ, my argument is that Judge Cordero found that that the constitutional claim was raised in the first 23-110, which means that it's not abuse of the writ. Abuse of the writ is if you didn't raise something that you could have raised. And the government agrees. The government has in its brief says he raised it. And so that's why they're arguing it was a successive petition. Moreover, as Your Honor noted, abuse of the writ, like any procedural bar, is discretionary. And so the court, in its discretion, Judge Cordero in her discretion, did not apply abuse of the writ because she found that it was raised in the first 23-110 motion. Now, as to successive, a successive motion does not bar, I'm sorry, the successive doctrine doesn't apply if the first claim was never denied on the merits. And, Judge Cordero and the government, both, only thing they cite is this paragraph at the end of Judge Holman's 7-page order saying, in summary, the defendant hasn't shown that his conviction was obtained. It's, in summary, petitioner fails to establish grounds indicating that the sentence imposed was in violation of the Constitution of the United States or the laws of the District of Columbia, that the trial court was without jurisdiction to impose the sentence, that the sentence was in excess of the maximum authorized by law, or that the sentence is otherwise subject to collateral attack. That is a direct quote from the language of 23-110. He's just saying you haven't met the statutory standards for a 23-110 motion. That is not deciding a constitutional question on the merits.
Well, I mean, you seem to be conflating the thoroughness for purposes of review of the trial court's ruling, which I get is an issue, with the term merits or the distinction between merits and non-merits. And I think generally speaking, when we think of non-merits decisions, we're talking about things like procedural decisions that decline to address the actual substance of the argument. Now here, we may not have a thorough ruling by the trial court on the merits, but that doesn't mean it wasn't a merits-based ruling, especially when your very argument is that CP raised the substantive argument in his motion. And we presume that the trial court had that before it, and in denying it with specific reference to the constitutional claim, then whatever we can say about the desirability or the thoroughness of the trial court's ruling, I don't think we can characterize that necessarily as not being on the merits.
So I don't think that he does specifically refer to the constitutional claim. I think what he's doing is the word constitution appears in this paragraph because it appears in 23-110. And I think that there's nothing at all. And I mean, this is in the context of a 7-page order that has detailed analysis of the statutory claim and why it's not retroactive, and zero mention of, zero evidence that there's any consideration of the merits at all, not just a thorough consideration, but any consideration. And the Supreme Court held in Sanders that just because it's denied does not mean that, even in Sanders, actually, the court the lower court said, I find that this claim has no merit. And then the Supreme Court said, that's not a decision on the merits when you haven't actually, there's no evidence that the court considered the actual substance of the claim. And I don't think I don't think there's any case law that suggests that just because it was decided that it must have been decided on the merits. I mean, there's zero evidence that it was actually decided on the merits or at all, really. I mean, I agree, Your Honor, Judge Holman didn't say it's denied on procedural grounds, but I just don't think he denied it at all. And so when the the whole point of the procedural bar for successive motions is that we don't want to waste judicial time if another court has already given that claim full and fair consideration. And we want to accord it finality and respect. But there's no evidence that there was any consideration of it all. And so we don't think that it was denied on the merits, that this stray language about the Constitution of the United States is simply in the context of quoting the standard for 23-110. And there's nothing above that. When it says in summary, there's nothing it's summarizing. And then, but I guess I will move on to the second point, which is that even if the claim had been previously denied on the merits, that the ends of justice would require that the claim be considered anew, because the fullness and fairness of the previous proceeding was undercut by the fact that Mr. Mr. P was pro se and not represented by counsel. The government argues that he wasn't entitled to counsel because his claim was barred by law of the case. And that all hinges on whether this court thinks that Lawrence overruled Harris and Buck, which we think it did. And then of course the ends of justice also require consideration anew, because if Mr. P's claim has merit, then he has shown that it's more likely than not that a jury would have acquitted him had it been correctly instructed on what we think are the only way that the sodomy statute could be saved. I think that those are the only two procedural. I think the government also raises a law of the case procedural bar, which, by the way, it waived by not raising below. But again, that all hinges on whether Harris and Buck continue to govern this case. And I think they don't, because they rest on the assumption that substantive due process sort of restricts government intrusion on things only in the home, which Lawrence very clear. I mean, there's a lot of things that Lawrence leaves unclear, but I think it's pretty clear that Lawrence says it's not just about places. Privacy and personal liberty are not just about places. It's also there are spheres of personal life that people should have, be able to make the kinds of choices they want to make about their sex lives without government intrusion, unless there's, an absent injury to the person or abuse of an institution that the public wants to protect. And so that holding, which is essential to its, that's part of the holding. It substantially undermines one of the key assumption in Harris and Buck about the scope of the due process protection of this type of conduct. And so given that change in the law, 23-110 is exactly the vehicle that allows people who've been convicted under an unconstitutional statute to relitigate claims that they made on direct appeal when there's been a change in the intervening law that affects the merits of their claim. There's no further questions, though.
Thank you, counsel.
Thank you very much.
Mr. Hansford.
Good morning, and may it please the court, Eric Hansford for the United States. The defendant's 1980 conviction for sodomy remains valid, and the trial court properly ordered him to register as a sex offender. Following counsel's lead and focusing this morning on the validity of the conviction, Lawrence holds or Lawrence does not protect public sodomy like the offense here. And Valdez holds that the sodomy statute remained in force as to anything that Lawrence doesn't protect, including public sodomy. And this is specifically the language from the Valdez case. We adhere to IAT's guidance and follow the normal rule by holding that the sodomy statute is still validly applicable to non-consensual conduct and other activity within its scope that is not constitutionally protected as set forth by Lawrence. Again, Valdez later reiterates.
How is public sodomy within the scope of the statute as written at that time?
Because the sodomy statute
It
as
doesn't
written,
say anything about public or private.
well, it covered all sodomy at that time.
Okay, and so if you rule out consensual versus the non-consensual, how are you drawing a line that's based upon the statute as opposed to a policy choice about private versus public?
So what Valdez says, as we understand it, is that you take the entire coverage of the statute, which is all sodomy, and then to do the savings analysis, you take out whatever Lawrence covers. And what Lawrence covers
But
is
Valdez
private
doesn't
consensual
say,
sodomy.
it doesn't say that we're saying non-consensual private sodomy. It says
It-
non-consensual.
No, I mean, that language that I just read, it says it still is validly applicable to non-consensual conduct and other activity within its scope that is not constitutionally protected.
And
As
so you're
set forth by-
asking us to read that language to mean public.
I mean, I think Valdez says that in footnote 112, in quoting the Virginia Supreme Court case. But Valdez does not say we're going to save it as to non-consensual conduct and we're going to reserve judgment on what we should do with the rest. Valdez instead says, here's how we're doing the savings analysis. We are taking out what Lawrence protects and we are saving everything else. And that, as Valdez notes, that's also consistent with how other courts have saved their sodomy statutes, and that's in footnote 112.
With
But-
that language you're citing, how significant is it that in Valdez, we said that it's not constitutionally protected as set forth in Lawrence, in your view?
I mean, I think it means that anything that Lawrence does not protect or the Constitution does not protect is saved within the sodomy statute. And I don't think the defense is right now disputing that public sodomy can be constitutionally forbidden, that the legislature has authority to say you can't have sex in public.
So Valdez was really making a two-step analysis, right? One is that under Lawrence, there is no constitutional right to public sodomy or sex in general. And two, we can therefore assume, maybe not therefore, we assume that we conclude that the legislature, and I want to ask you after this whether Valdez was focusing on the legislature at the time the sodomy law was passed or now, but it seems to be saying the current DC Council would want the sodomy law to exist with respect to anything that is not constitutionally protected.
I'm not sure if Valdez makes the first, I mean, Valdez recognizes that public sodomy is not protected. I think it's Lawrence that repeatedly, dozens of times in the opinion says what we are protecting is sodomy in private. And I don't think anyone is really disputing now that, the current statute, which outlaws sodomy in public, no one is saying that's unconstitutional. I think everyone agrees it is constitutional. And especially when you have the background of this court's decisions, including the en banc decision in Harris that says whether or not private sodomy is constitutionally protected, as Lawrence later found, public sodomy is not and remains a valid basis for prosecution. I think with that background, in addition, it's clear that public sodomy is outside the Lawrence protection and therefore validly within the sodomy statute.
How would you define public sodomy? The first sentence in Lawrence is liberty protects the person from unwarranted government intrusions into a dwelling or other private places.
Yes, and so I don't think we dispute that, and I don't think we have offered, and I don't think the prior case law has offered, nor is it necessary to offer a comprehensive definition of public or to draw the difficult lines of like what you do with a tent, for example. What instead the court's cases like Buck and Harris and Stewart recognize is that when you are out in public, such as in a wooded area, such as at a canal, out in public, if you engage in sodomy in that context.
Those analyses were if you're outside your house, essentially, those analyses were, I don't read them as, well, no, I believe it was, yes, Harris says, sexual acts not protected in a commercial establishment open to the public, and so refused to even consider if it mattered if the doors to the cubicle in the health club were closed or not. Essentially, the decision rested on the fact that it was outside of a dwelling in a public commercial establishment.
I do not understand those cases. I think there's one reference in Buck to it being outside the house, but in the vast majority of those cases, they are not saying everything outside the house is unprotected. They're instead just saying whatever the scope of the privacy protection is, it's when things are occurring in a public park, for example, that is not going to be private. And that's exactly what we have here, is there's a clear public area.
Well, this case is distinguishable from Buck, where they're in a car. In this case, in Buck, they were not in a car. How are you supposed to draw the line there?
I mean, so as to this specific case, that is the issue that was decided 45 years ago in the direct appeal. The only issue that was raised on the direct appeal was this private or was this public? It was fully briefed in that case, and this court upheld the constitutionality of the conviction. The trial court had explained that it was public and not private. Prior to Lawrence, but Lawrence doesn't change the public-private analysis. Lawrence doesn't say anything that would suggest that this would be constitutionally protected, and I don't understand the defense to be making that argument now. I don't think they're saying that you have a constitutional right to have sex in the congressional cemetery. I don't think they're saying.
I think what they're saying is it's the legislature should say what the constitutional right.
So as to the legislature.
The legislature should say that if that's prohibited or not.
So as to the legislature, what the legislature said is all sodomy is prohibited. That's 1948, Congress passed that, and it's reenacted in 1973 by the DC Council as part of the comprehensive criminal code scheme. And so that is the judgment that was made by the legislature. And then IOT says, if you look at IOT, it says, what we do is we try to save as much of the statute as possible. Where we can enjoin one specific portion of it, I can use the actual IOT language. We prefer to enjoin only the unconstitutional applications of the statute while leaving other applications in force, or to sever the problematic portions while leaving the remainder intact. We try not to nullify more of a legislature's work than is necessary, for we know that a ruling of unconstitutionality frustrates the intent of the elected representatives of the people. And that is exactly what this court recognized in Valdez. That's exactly what this court did in Valdez. Valdez is binding on this panel. This analysis, the savings analysis, has already been done by the court in Valdez. And Valdez determined that anything that's outside of Lawrence is what we save. In terms of Judge Schenker's earlier questions about which legislature we're looking to, I think in reading IOT, it makes sense. The only way to understand that, they're talking about what the legislature intended, past tense. So the way to understand that is what the legislature that passed the act would have wanted at the time, but with these thumbs on the scale, including that we're going to try to save as much of the statute as possible. And I think it's notable in terms of the 1993 enactment. Prior to that,
Is it your argument that it doesn't matter that there was no jury finding or no jury instruction, that it was non-consensual because it was public, and so it's then separately prohibited as public?
So as to the jury instruction issue, that's a separate claim. That's a Sixth Amendment claim.
I'm not
And-
talking about the jury instruction issue. I'm talking about whether or not it was prohibited conduct under Valdez. I'm talking about the fact that the jury didn't make a finding as to the consensual nature of the act. And what you're saying is that's irrelevant to the interpretation because separately, the public act of the sodomy was prohibited.
I mean, I think maybe I'm misunderstanding the question, but the defense is suggesting that there was also separately, even if we're going to save the statute as to this, a separate Sixth Amendment right to have the jury make the finding as to the public-private. But that is an argument not only that was not raised in the direct appeal where all of this was fully litigated, but was not raised in the 23-110 proceedings below. So this is clearly not.
The question from my colleague is, do you think that's even necessary for us to get into under your interpretation? Because under your interpretation, it sounds like the fact that it's public means it doesn't matter. We don't need to worry about consent. It's already illegal.
Correct. And that is certainly our view.
So along those lines, since you brought up tents earlier, is every act of sodomy is defined under the act by every unhoused person in DC in or around a tent or anywhere else than a violation of the law?
So we are not making the argument that public-private is limited to the home. And I think in the most notable Supreme Court case on privacy before that's being discussed in these Harris and Buck cases is the Paris Adult Theater case that we refer to a few times in the brief. And in that case, it recognizes that there are situations outside the home where there is privacy, such as a hotel room, such as a doctor's office. We are not making an argument as to tents. We are not making a kind of categorical argument that anything that occurs outside the home.
But a car in an obscure location does not fall under that.
Yes, that the mere fact that it was secluded is not enough, and that's what Stewart recognizes and Buck recognizes. And the car aspect, which, by the way, when this issue was litigated, when we had full trial transcripts 45 years ago, was not something that the defense was referring to. The fact that it's in a car does not make it constitutionally protected. And indeed, there are multiple, as we cite, public masturbation or indecent exposure cases that involve people in cars. And I'm not aware of a suggestion that the fact that you're in a car would protect that conduct. And there's no sort of suggestion that the defendant in this case was unhoused and was living out of his car. If I could just finish as to the 1993 enactment, prior to the 1993 enactment, in 1982, the DC Council did attempt to enact a similar provision that would have limited the sodomy statute to consensual conduct. Congress overrode that, and that was actually a basis for the defendant's motion to reduce sentence in 1982. But Congress overrode that. So I think it's important to recognize, one, that Congress is also an actor that we have to look to in this context. It's not just a DC Council question. And two, if we are looking for, post-enactment history as to what the legislature was doing, it's much more telling what happened in 1982 than it is what happened in 1993 when we had a very different understanding of how these sodomy statutes were being applied. If there are no.
I know that counsel on the other side didn't have a chance to address this, and maybe we can ask her when she gets back up. But on the SORA question.
Yeah.
Does the government agree that if this issue had been preserved, we'd have at least a significant Apprendi question with respect to proof of the, significant Apprendi question?
No, Apprendi is a Sixth Amendment, is primarily a Sixth Amendment right about the Sixth Amendment jury trial. The Sixth Amendment applies to a quote unquote criminal prosecution. And it provides a variety of rights that simply do not come into effect in the civil SORA context.
But isn't that what we said in Fallon?
Well, Fallon is a Fifth Amendment case, and it found the distinction between the Fifth Amendment and the Sixth Amendment very important because it was bound by WM and its characterization under other provisions of this enactment as civil. So, but in terms of why the Sixth Amendment wouldn't make sense to apply in this context, the Sixth Amendment gives you, for example, a confrontation right. It gives you a right to be tried in the place where the crime occurred. The crime occurred here in many of these SORA cases, the crime occurred in a very different jurisdiction from where you are now being forced to register because you've moved to the district or you work in the district, even though, for example, in Cox, it's a Wisconsin conviction. So the Sixth Amendment framework just doesn't work in the SORA context. And so just picking out the jury trial right from the Sixth Amendment and trying to engraft it onto this SORA context doesn't work.
I'm confused because Fallon is a Sixth Amendment case.
So Fallon is a Sixth Amendment case, and it says when you are being charged for a crime, when there's a clear criminal prosecution. So in that case, he was being charged with misdemeanor sexual abuse of a minor. So based on that, we are going to, because you are in the Sixth Amendment world, we're going to
But
say.
here, there was no Sixth Amendment determination that, I mean, he wasn't determined to have non-consensual sex. And so when he was required to register for SORA, there was an administrative determination made that he had a forcible sodomy encounter that was then determined to be forcible by the trial court judge. I mean, how is not determining whether or not somebody has committed a forcible sex act a Sixth Amendment issue?
So I think I need to distinguish between two different Sixth Amendment claims that the defendant is making, neither of which is preserved. The Sixth Amendment claim that I was talking about with Judge Schenker is in the SORA context. The argument that in determining whether or not SORA applies to me, I should get a Sixth Amendment jury trial. And I'm saying that that SORA is not a criminal prosecution. So the Sixth Amendment doesn't apply there. Then there's the separate claim that in 1980, I should have gotten a jury he did get a jury trial in 1980, but there's a separate claim, again, unpreserved, that the defendant should have in 1980 had a jury determine whether it was public or private, as opposed to a judge make that determination. And so.
Well, that's separate. I mean, I understand the
Sure.
distinction you're making, but that's separate from my point. Because my point is there was no determination under the SORA registration requirements as they existed at the time he was determined to be registered, that he had committed a forcible sex act.
The judge made that determination as allowed by SORA.
So that's where in SORA does it say a judge can make that decision? And how does that not violate the Sixth Amendment?
So that's 4004. It says the judge, when there's a dispute as to whether SORA is going to apply.
Sorry, how is that not a Sixth Amendment violation?
I have to distinguish between, are you saying it's a Sixth Amendment violation in 2023? When the judge is determining, so that is not a criminal prosecution. So the Sixth Amendment doesn't apply.
Okay.
Because it's within SORA, the Sixth Amendment just doesn't apply, and it wouldn't make sense to apply the Sixth Amendment. There's all sorts of procedures that apply in these SORA proceedings that do not apply in criminal prosecution.
Well, I mean, I think the claim, although I'm confused because there was the footnote in your brief about how CP had disavowed a constitutional challenge to 22-4004. So maybe that's a question for when counsel gets back up. But I think the argument, and maybe I'm wrong, is that for a trial court to find by a preponderance of the evidence that a fact imposes lifetime registration, when we have said in Fallon that type of result is punitive for purposes of the Sixth Amendment, although perhaps not for the ex post facto clause, but is punitive for purposes of the Sixth Amendment, that would translate to that determination by the trial court by a preponderance and would require a jury finding beyond a reasonable doubt under Apprendi when we are increasing the punishment that the defendant is subject to, that would require a jury finding beyond a reasonable doubt under Fallon.
Right. So I mean, number one, Fallon can't overrule WM. It's bound by WM and its assessment of those procedures. Fallon's just a panel opinion like WM.
Well, but
number
WM
two-
was an ex post facto case. Fallon said that in the Sixth Amendment context, it's punishment.
So yes, but in a criminal prosecution. The Sixth Amendment textually is limited to a criminal prosecution. So it only works to make a Sixth Amendment analysis when you have a criminal prosecution. And what you use in a civil context is procedural due process, which is what WM is using in terms of that in its analysis as to what standards should be applying in that context. But then the Sixth Amendment context, it is only in a criminal prosecution that's going to kick
I
in.
see
And
your-
SORA is
okay.
not a criminal. A SORA registration is not a criminal prosecution. Instead, that is assessed under due process principles. And I think notably, the text is clearly limited or clearly contemplates a 4004C, a judge making that determination in its sole discretion. And it does not contemplate bringing a jury trial. So based on that, and
It can make it, the judge can make a determination as to whether or not a specific conviction falls within the requirements of SORA. But can the judge make a determination that an underlying conviction that doesn't fall into one of the specific categories? Because isn't it the difference between deciding if this conviction applies and reading into the record a finding that was not made by the trial court? Or by the jury, there was no finding of forcible.
well,
And what the judge at the trial court decided is that it was forcible.
but what SORA specifically contemplates is the making the factual determination in the latter. We go through this on 34 to 36 of our brief. And I think also in the background section, but what SORA says is when
I'm looking at SORA and
Yeah.
I guess I just disagree with you.
It's helped me to understand. The way I read SOAR, it looks like a judge should look at the surface of this and should make a determination, does this apply or does it not? And it feels like some algebra happened here that really implicates the underlying criminal determinations, less so than the civil determination of, does this square peg fit into this round hole?
So I think
Horrible analogy to use.
I think what SORA is contemplating is specifically a factual finding in this circumstance, and that's what WM and Cox recognize. So maybe the better place to point you to is 29 to 30 of our brief. So it says, so you are subject to registration if you committed a sodomy offense where the offense was forcible. And then CSOSA makes the initial determination as to whether you should be subject to registration. And then once CSOSA makes that determination, this is under 4004A2, you can seek review of that determination with the trial court, including a finding that certain acts or contacts were forcible. And then in 4000C1, it says the court may, in its sole discretion, resolve these issues, and it may do so by looking at the motions, affidavits, the files and records in the case, other written documents, proffers of the party, or an evidentiary hearing. But what these contemplate is explicitly the trial court is making
Here's what I meant, like in Valdez, right? There was the determination, it was with a weapon, right? So a judge can easily determine, okay, well, that was forcible. It doesn't use the language forcible, but the charge on which they were convicted was a sex act with a weapon. So that is a judicial determination, I think, that could be made as to whether or not it was forcible. But that's very different than when there was no underlying jury verdict on a sex act that required an evaluation of if it was forcible or not.
That's explicitly what WM and Cox are dealing with in their holdings. as to whether or not in WM, the 1968 sodomy conviction that the defendant had, whether or not that was forcible. There was no jury finding as to that, but the court says, trial court, go look at all the police records as best you can and make a determination at the preponderance of the evidence standard as to whether or not it's forcible. Same thing in Cox as to the Wisconsin conviction that the defendant had. In that case, that wasn't sodomy, that was a different sexual assault. But in both contexts, it's saying, trial court, you are making a finding of forcibility at the preponderance level. And this court is then only reviewing for sufficiency of the evidence as to the finding that there was a preponderance of the evidence that it was forcible. So that this court would have limited review of that. And again, insofar as this court would have questions about this, the defendant raised none of these kind of quasi-constitutional arguments below. The only argument below was as to whether or not it was forcible. If there are no questions, we'd ask this court to affirm.
Thank you.
I'd like to address first the government's argument that Buck and Harris did not purport to draw the line at the home. I think if you read those cases, that's exactly where they drew the line. Harris says, the appellant argues that the sodomy statute is broad enough to be applied to conduct within a private abode, which is protected by the Constitution. But we are not going to, we're going to say that he doesn't have standing to raise that claim because the conduct at issue in his case occurred outside the home in a commercial establishment. Buck says, Buck first rejects the idea there is a constitutional right that covers any of this conduct, but says in any event, it wouldn't extend outside the seclusion of the home. And the reason they do that is because the only Supreme Court case law that existed at the time that addressed substantive due process were the ones that they were focused on were Griswold and Stanley, both of which very much were bound up in the idea of the home.
But would you agree that even post Lawrence, a legislature could constitutionally ban public sex?
Well,
I mean, put aside line drawing, that courts have to deal with that all the time. Legislatures should try to draw that line. They sometimes do, they sometimes don't very well, but that's not a constitutional question. I mean, unless you get into vagueness challenges, which we're not talking about here.
right.
But constitutionally, a legislature could ban let's just stick with public sodomy.
So what Lawrence says is it holds that liberty gives substantial protection to adult persons in deciding how to conduct their private lives in matters pertaining to sex. And then it also says that that absent injury to a person or abuse of an institution the law protects, that the government shouldn't be regulating people's sex lives. So I think there are, so in some ways, the constitutional line depends on sort of what the government justification is for regulating the sex. And so, yes, I agree that the current indecent exposure statute, which makes it a misdemeanor to have sex in open view before the public at large, that harms the public interest in a small way, but as reflected by the punishment. And so that would be constitutionally prescribed.
Okay, so then, I'm sorry, I'm cutting you off, but I'm trying to stay on my own train of thought without losing it. But then, so in Valdez, we said that we conclude that the DC Council and Congress, and again, it's unclear in Valdez, and I realize I was on that case, but which council we were talking about, but would want the sodomy law to cover, and I'm paraphrasing here, everything that is not otherwise constitutionally prescribed. And we already made that determination in Valdez. And so hasn't that ship sailed? And I don't want to overstate what you just agreed to, but correct me if I'm wrong, you at some level agreed that Congress or the DC Council could constitutionally proscribe public sex, public sodomy. So how are we not just bound by Valdez at that point?
Because I don't think that, to the extent Valdez said that, it was at all focused on the IOT question is applied to public consensual sodomy.
But I mean, it specifically added a little, clause saying including public acts. Again, I don't have it right in front of me.
Right, and Valdez did not purport to figure out what public means.
But that's not really the question, right? I mean,
It is
that's
the
for
que-
another day. The question is, I mean, Valdez, made it kind of a larger proclamation, which is we're going to assume that the DC Council, and I think this is a more reasonable conclusion if we're talking about the council in 1948 or 1973, but either way, would have wanted the sodomy statute to cover everything that it could have, except for what is constitutionally not proscribable. And that's what we said, right or wrong.
Well, I think that, the judicial mind, I don't have the language on my fingertips, but, questions that lurk in the record or, that are sort of adverted to, but not, the judicial mind did not pass on the question of, would Congress and or the DC Council have wanted to continue proscribing under the sodomy statute consensual public sodomy. That was not at all at issue. It was focused on non-consensual sodomy because that's what the jury convicted Mr. Valdez of. And to the extent that there's this extra add-on language, and we submit that's essentially dicta because the judicial mind didn't pass on the very important IOT question that even Valdez thought was important. Valdez said we have to go through the question of, is this within the judicial role? Is this something that is going to require difficult policy choices the way it did in Tilly? Is this something that the legislature would have wanted? Is this something that the jury found? Those are all integral pieces of the Valdez holding. And it did that with respect to non-consensual sodomy. It said it's clear and undisputed that non-consensual sodomy is not within the holding of Lawrence. It's clear, we have no doubt that the legislature would want to continue punishing non-consensual sodomy because it's always been punished very severely. It simply did not address any of these very important jurisprudential questions we are raising with respect to public consensual sodomy.
But it's against the backdrop of AOT's reference to the fact that the default or the presumption should be preserving as much of this existing statute as possible.
Yeah, so I do want to address that. So the government basically says that treating that as the touchstone would actually just read the IOT question out of existence because it's anytime the legislature bans all of something, then that original legislature intended to ban all sodomy. There's no question, but it's not a question of statutory interpretation and deciding what that particular legislature wanted. The question is, would the legislature have preferred what is left of its statute to no statute at all? If this court could always presume that a legislature would want to save as much of its statute as possible, then there'd be no point in asking that question. And the Supreme Court said a court must ask that question. And in fact, IOT specifically remanded to the lower court to answer that question.
I mean, it's a strange question unless you start getting into the question of which legislature are you talking about, because then you could make a distinction, a decision whether the current legislature would want it written that way. But if you're looking at the original legislature, you'd always have to assume that they would want as much to be banned as they could possibly have banned, given what they wrote in the first place.
Exactly, and that's why it can't be the original legislature, because the original legislature had an unconstitutional purpose or assumption, which is that all acts of sodomy can be banned as unnatural and perverted. And that's the very constitutional problem that we can't sort of give full faith to that invalid purpose. Lawrence said that that a government's judgment that an act that sodomy is immoral is an invalid basis for proscribing sodomy. And so if that's what the original legislature was doing, which we know that is what it was doing, it can't be the original legislature's intent. In fact, really the IOT and Conley question about sort of what would the legislature want, again, not a question of statutory interpretation. It's a test of the legitimacy of the judicial remedy. It is asking this court, when we try to save this statute, are we really doing what a court should be doing, like, simple thing like severing portions that are unconstitutional or reading a really simple element that everyone understands, like non-consent, into the statute? Or are we effectively rewriting the statute to conform with constitutional norms? And this test is designed to suss that out, like is to kind of test the legitimacy of the judicial remedy. It's not about legislative intent, which is why Valdez says we have no doubt that Congress and the DC Council, which obviously, you know, because if we can't be confident that this is exactly how the legislature would want to save the statute, then the court should refrain from interfering with the statute and let the legislature fix it. And normally that's what happens. And it would be this legislature. It wouldn't be the 1948 Congress. It would be the current legislature. And so again, it's a sort of more a conceptual question than a question of historical fact, is sort of, well, given what we know about what legislatures do and what our legislature has done, is it so obvious to us that now that we know that the legislature knows it cannot ban sodomy in all its forms because they think it's unnatural and perverted? Is there a reason that this court can be confident that the legislature would want to treat consensual sodomy in public the same as non-consensual sodomy? And I think the answer is pretty clearly no, because it never has treated those two things the same way in other types of sex. So, I mean, there was never, prior to 2011, there was never a statute that made it, for example, a crime to have vaginal sex in public. That was, you know, it sort of just happened to be that public sodomy fell within the scope of the sodomy statute because it punished all sodomy. But now that you can't punish all sodomy, it's a legislative choice to decide whether consensual sodomy in public should be a crime under the sodomy statute. And moreover, I think that, you know, when we say, like, look at Harrison Buck, look at Valdez, they already said that public sodomy is not covered. Those cases did not define what public means, other than in Buck and Harris to say it's outside the home. And even the governments are saying, we're not arguing that because that would be probably maybe unconstitutional, and definitely not what the legislature would want. And so drawing the line as to, does it apply to a person's private car, especially when no one can see them? Is that constitution protected? Maybe it is. We don't know. It's a murky constitutional context. And that's what Ayat said this court shouldn't be doing. If the background constitutional principles don't make this an easy judicial fix, where you're just either severing a provision or reading in some element like non-consent that is everyone knows exactly what that means. If it becomes murky, if it requires policy making, if it, these kinds of balances, especially because the constitutional right at issue is about freedom from government intrusion. And when the government has good reason to intrude on a person's sex life, then it can do that. But it's the legislature's decision whether it has good reason. It's not up to this court to decide whether it has good reason. And so, again, that's also why, you know, when we have this, Valdez very much, it was integral to Valdez's holding and upholding Mr. Valdez's conviction that the jury was actually instructed on non-consent as an element of the offense. And if this court were to try to narrow the statute to public sodomy, and then it would have to decide on harmlessness, it'd have to know what public means, because yes, this was outside the home, but no, it was not. We think that that a jury very much could have and probably would have acquitted if the instruction was it an open view? Because there was no evidence that anyone could see inside this car. It was a private car, his own car. It was parked in the far recesses of Congressional Cemetery. Clearly, they went there because they didn't want anyone to see. It was dark. There was the complainant's own testimony was that there was no houses, other people, or lights anywhere. And so a jury with that kind of evidence, I don't think this court can find under Chapman that this was in open view. And the legislature made the considered decision that it would only punish public sex as a misdemeanor, 90-day misdemeanor, not a 10-year felony, if sex is an open view, because that's when it harms the public enough to make it a crime. And so at a minimum, I think that would have to be what the definition of public is, not just outside the home, the way Harris and Buck said, because Harris and Buck were not thinking about what the legislature wanted to do. They were just saying, based on the Supreme Court case law we have, Stanley, Griswold, those are all about the home. And so we have no reason to think that one day when the Supreme Court recognizes, if it were to ever recognize a constitutional right that extends to sodomy, that it would go outside the home. Stanley and Buck and Harris and Stewart were not deciding whether the sodomy statute could be saved to apply to public sodomy and then deciding where that line would be. So we think that Buck and Harris just don't even have anything. They're implicitly overruled by Lawrence for one thing, but they also just don't answer the question of what does public mean within the limits of the Constitution and within the limits of what the legislature would want the sodomy statute to apply to.
Counsel, with apologies to everyone in this room who's been in here for 3 hours, but on the SORA question,
Yeah.
am I misunderstanding your argument to be that in a civil 4004 proceeding, to be consistent with Apprendi, facts that result in lifetime registration or any increased SORNA penalty have to be found beyond a reasonable doubt? Or
Found by a
I
jury,
think your
found
argument
by a
was clear
jury,
and
yeah.
convincing, but sorry, go ahead.
Found by a jury, consistent with Apprendi, and also at least something heightened beyond a preponderance.
So,
under
I mean,
procedural due process.
it seems like then you are at some level challenging the constitutionality of 4004, which, I mean, we probably should have had the district here. But number two, I don't see how that's, I mean, that does, well, I just don't see how that follows when 4004 is a civil proceeding.
Okay, well, I'll address the two separately. I don't think, we didn't conceive of this as a challenge to the statute because the statute doesn't say what the standard of proof is. That was supplied by WM under a procedural due process analysis. And so we're saying that the procedural due process analysis should be revisited in light of Fallon's recognition that the harm to the individual is a lot greater than what WM previously recognized. You know, we didn't view that as that's just a procedural due process claim that is asking this court to revisit WM's conclusion. As to the Apprendi Fallon argument, again, the statute doesn't, there's nothing about the statute that would preclude a court from limiting its fact finding to facts that have been found by a jury. So for example, you know, one of the, so for example, you know, in Valdez, the court could have looked to what the jury found.
Yeah, I mean, nothing stops that, but you seem to be saying the Constitution requires that.
Yes, it
And
does.
what's the basis for that? When we have a civil procedure, I mean, I assume you're accepting the premise that it's a civil proceeding.
Yes, because we don't think that the Apprendi principle applies so woodenly only to things that are considered criminal trials, because the Apprendi principle is that any fact that increases the maximum authorized penalty for a crime cannot be done by a judge. And whether you separate out that imposition of the additional penalty into a civil proceeding doesn't change the Apprendi principle. You can separate out those proceedings into however you want, but if it increases the penalty.
I'm just not sure of our court or any court applying Apprendi in a civil proceeding, but I haven't looked, so.
Well, so one example, which again, I agree, is a very sort of up for grabs open question, is whether like civil restitution is subject to Apprendi. And we cited, I believe, an opinion by Justice Gorsuch, who, you know, which strongly suggested that he thought that Apprendi does apply to restitution, even though you could have a separate civil restitution proceeding that is not part of the criminal prosecution. It's just part of the penalty imposition. And I think it's still an open question as to whether Apprendi would apply in those situations. And I agree. I don't have any precedent to cite. We're arguing from constitutional principles that were established in the Apprendi line of cases, Southern Union, which held that if the penalty is severe enough to trigger the Sixth Amendment right to a jury trial under the Blanton analysis, then Apprendi applies in full. That's what it says. And that's what we're relying on. And Fallon did hold that SORA, that registration is a severe enough penalty to trigger the Sixth Amendment right to a jury trial under Blanton. And so we think it follows that Apprendi applies in full.
So it is limited in this case just to where we are missing a finding.
Yes.
And in a regular case where findings are made with modern jury instructions, et cetera,
Correct.
doesn't matter.
Correct. And in fact, so for example, another application of this would be, you'd be a lifetime sex offender registration would be required if the sodomy involved, I think it's a minor under the age of, I forget the age, I think it's 16. And so under the sodomy statute, under the former sodomy statute, that was a separate provision that required an enhanced penalty, and that you may well have jury findings about that. I'm also not disputing that Apprendi errors are subject to harmless error analysis. So this is really a challenge to this particular situation where a judge imposed the severe penalty of sex offender registration for a crime of sodomy based on her own judicial fact finding and not based on a jury finding, which we think violates the Apprendi principle.
So given that this quacks and waddles a lot like a constitutional claim, do you think in an abundance of caution, it would be best for us to seek supplemental briefing and include the district on that?
So, Rule 44 says that if the constitutionality of a statute is drawn into question, that notice is required. That doesn't mean that every time there's a constitutional claim that Rule 44 is implicated. Again, like I said, we don't think that the statute is necessarily in conflict with what we're saying, is that when a judge is going to impose this penalty, there needs to be a judicial fact finding. The statute doesn't say you can't do that. I mean, we're not challenging the statute based on the Constitution.
Thank you all for your time and arguments and lots of time. The case is submitted. Everyone have a good day.